Let me pull up YouTube. One sec. Testing 1 2 3. Testing 1 2 3. This is a test of the Seventh Circuit Court of Appeals YouTube page. Testing 1 2 3.
United States Court of Appeals in and for the 7th Judicial Circuit. Hear ye, hear ye, hear ye. All persons having business before this honorable court are admonished to draw near and give their attention as the court is now sitting. God save the United States and this honorable court.
Good morning, everyone. We're here today for oral arguments. We're going to begin with appeal number 24-1026, Daniel Christensen et al. Versus William Weiss et al. And Mr. Aiken will begin with you.
May it please the court. I am Michael Aiken, and I represent the estate of Donna Christensen by and through her next of kin, Daniel Christensen, related to several constitutional violations that resulted in Donna Christensen's suffering and ultimately her suicide at the Vilas County Jail in northern Wisconsin. The district court in this case dismissed the 1983 constitutional claims on a motion for summary judgment and also dismissed the supplementary state law claims without prejudice. This appeal presents a straightforward series of procedural issues and a more complex set of issues relating to the substantive constitutional violations. The straightforward issue is the district court abused its discretion related to a surprise and premature summary judgment deadline and refused to allow additional time for discovery.
But didn't the parties agree to a 2 or 3 week stipulated new deadline and requested that of the judge?
I believe that when the status conference was held after the initial scheduling order was struck, counsel was wrong-footed at that point, and that was indicated in the docket entry that they were not prepared to file a motion for summary judgment. There was a prior stipulation to extend the deadline as the parties were working together and knew that the record was not ready for summary judgment at that point.
And Mr. Aiken, we do have quite a bit of briefing with regard to the procedural issues. I'd like to focus in, and you can certainly return to those if you wish, but I'd like to focus in on the claim against Officer Wilmot.
Yes.
Is the theory a straightforward one of excessive force, or is the theory what the district judge called the roundabout theory, the series of elements that would together aggregate to your thoughts with regard to a theory of prosecution?
It is a straightforward use of unreasonable force against Officer Wilmot, and that use of force was captured on video, and it's our contention that Ms. Christensen's side of the story that's shown on video is not blatantly contradicted, so it would fall under the Supreme Court's decision in Scott. And there's multiple evidence of maliciousness to satisfy deliberate indifference, starting with the fact that the officer observed her susceptibility to being in solitary conditions, how that affected, revealing an obvious mental illness, and he still continued to punish her for the maximum allowed punishment of what amounted to 30 additional days in solitary confinement.
So let's examine that second element. As I understand the roundabout theory, first, the allegations Mr. Wilmot used excessive force to thrust Donna into him. Second, he violated her due process rights by disciplining her with this confinement, which you mentioned. And then third, his discipline combined with mental illness ultimately led to the suicide. On the second element, the violation of the due process rights by disciplining her, how is that a violation of the due process rights? How is placing her in that 10 days of segregation, how does that result in a due process violation, that second link of the chain?
Yes, so the due process violation relates to the fact that Officer Wilmot was not only the officer that was involved in the use of force, he also was the supervising officer that was supposed to look at the use of force and determine if that was reasonable. So he signed off essentially complying, that he himself complied with the obligations. He did that because he testified he thought that that would mean that his conduct would not be further subject to any further review. And he essentially tricked Donna Christensen into waiving her due process rights by promising her that he would put her back near people. And even though she expressed 10 days was a long time to be alone, didn't tell her that she was going to be on the hook for 30 days. So it's the signing off on his own conduct and then also essentially tricking Ms. Christensen into waiving her due process rights that we believe is a due process violation.
And just so I get the clarity on the theory, there has what we've called this roundabout theory with the three elements. The other theory would be just a straightforward allegation of intentional use of excessive force. That's also the first of the three steps in the roundabout theory, is that right?
Yes, I mean, these things, what makes this case complicated is the different violations sort of are intermingled, but I think combined, how you look at them, they show that the action by Officer Wilmot was done with malicious intent rather than a good faith effort to maintain order in the jail. And it was my intention to spend more time on the substantive constitutional violation issues rather than the procedural issues, because those are set forth in the brief. And so those issues are whether Donna Christensen was denied a right to medical evaluation and treatment for her obvious signs of mental illness, whether there was reasonable precautions taken based on a substantial awareness to the risk of suicide, and then, as you mentioned, the unreasonable use of force. In terms of the medical evaluation and treatment, we must show a serious medical need and deliberate indifference. And a response to the serious medical need or lack thereof can constitute deliberate indifference. And that can be shown if there's no medical care provided, or if there is some medical care that it evidenced a complete absence of medical judgment.
What evidence do we have that the RN, Linda Thayer?
Yes, Nurse Thayer.
Okay. What do we have of deliberate indifference there?
As far as deliberate indifference with Nurse Thayer, the record is somewhat incomplete on that fact because of the summary judgment deadline that was imposed by the district court. We didn't have the opportunity to fully explore how she may have been involved in terms of setting policies that were unconstitutional. And as far as proving her deliberate indifference, if she's part of this system and would have been someone who was part of the planning of this system to say that it's adequate, where you're having someone who's unqualified and herself testified she could only give support and encouragement as opposed to any medical care. Those issues still need to be developed, and that's one reason that the procedural issues in this case do bleed forward to the substantive issues in terms of the constitutional violations. We still think, though, based on the record that we have, there's enough evidence where the court can move this case forward as to the primary defendants. Ms. Thayer, and there's also a physician's assistant, Scott.
Gregory Scott?
Yes. He's another person who, at this point, with the record being what it is due to the procedural issues, we don't have a full understanding of how he was involved. And we know that from the record, he did not see Donna Christensen, he did not evaluate her records, but yet his signature was used on the form that released her from Suicide Watch. So they were using him in order to do what they should have done, which is to have a medical evaluation of Ms. Christensen when she's showing, professing a threat to commit suicide and saying that it's because she's hearing constant voices telling her to kill herself for weeks leading up to her placement in the jail.
Well, let's turn then to focus on Ziemba, okay, the mental health professional. I do take your point that it seems that someone who's presenting as Ms. Christensen did could use more than support and encouragement. That's the quote, and I thought that came from Ziemba, not Thayer. Does the record tell us whether this is some sort of policy of these ACH defendants? What's routine when folks are coming into the jail who are withdrawing from their substance abuse? What does the record establish? And I understand that you're saying you weren't able to finish developing some things because of deadlines, but what did you have in there?
Yes, in terms of what we have in the record, we know that Kayla Ziemba testified that she could only provide support and encouragement and couldn't even refer out for any medical evaluation or treatment because it wasn't allowed under her understanding of the law. I think a reasonable inference can be made that she must have gotten that understanding from her training from ACH, and that was their policy, that they're not going to allow her as a qualified mental health professional, regardless, to refer someone for medical evaluation or treatment until they get out of the jail. So we think that is an important part of the record in that regard.
And by that, because to me it was not clear from the record, was she talking about refer out for medical evaluation and treatment of the withdrawal, the substance abuse issues, or specifically the mental health issues?
I believe that that was related to the obvious signs of mental illness. In terms of withdrawal, we know that when Donna Christensen turned herself into the jail because she was out on parole, she was withdrawing from drugs, and an officer noted that she was having severe withdrawal symptoms and said she should be seen by a nurse. No nurse ever saw her for that, and she was put into essentially what amounted to solitary conditions for COVID precautions. The Wisconsin law and the jail policy says you've got to have a medical evaluation within the first 30 days, and that didn't even happen in this case.
Was
It
she
happened
being
afterward.
held out, I guess, by ACH as a clinical social worker?
She was held out by ACH as someone who was properly qualified to be a mental health professional in the jail. However, even according to the jail's own job description, it required someone who was fully licensed. And
that's why taking you back to my question. I understand what the policy is. I need to know whether or not she was being held out as a licensed social worker to be in compliance with that policy.
I believe she was being held out by ACH to be compliant with that policy. However, it's worth noting at the time that she was working toward her licensure, the only way you can do that is if you're having supervision from someone who actually is licensed and is trained. And in this case, there's no evidence at all in the record that she was ever trained, and there's no evidence to suggest she was ever actually supervised. The person, Melissa Caldwell, who's not a party to this case because we weren't allowed to add her due to the procedural issues with the summary judgment deadline, she had testified that she was, or Kayla Ziemba testified she was never even at the jail. She was never present for any of her interactions. And to me, the fact that Kayla Ziemba didn't as much as consult her supervising person in a case like this, it speaks volumes in terms of what that relationship actually was. And the district court just assumed that that supervision was present, and there's no evidence that that actually occurred in the record.
Thank you.
Mr. Aiken, let me contrast a statement Judge Peterson says on page 2, plaintiffs concede that they can't prevail in showing that any of the defendants were aware of a substantial risk that Christensen would commit suicide. But then the argument, obviously, that you end with in your brief is a reasonable jury could find defendants were deliberately indifferent to a substantial risk of suicide. Is your position that the district court incorrectly apprehended your theory?
Yes, Judge, it is our contention. I don't know where the judge in the district court got that, made that conclusion, but I think what it was is there's a difference when you've got someone like Donna Christensen who's had a history of suicide attempts, threatened suicide, a vulnerability to solitary conditions, and obvious signs of mental illness. You don't need to have immediate signs like you would for someone who's a sane person and having momentary, signs of suicide to be able to stop them. When you take someone and you put them in that position with everything that Donna Christensen had, you take no reasonable precautions whatsoever, and you give her no medical evaluation. Our contention is that that substantial risk of suicide is still existing. She essentially, went from suicide watch, the frying pan, right into the fryer, and now she got put in a part of the jail where she was completely isolated for the last 10 days of her life, and nothing was done. And so that's the difference where I think the district court may have misapprehended that.
Would you like to reserve the remainder of your time?
I would, Judge, thank you.
Thank you very much. Thank you, Mr. Aiken. Mr. Knott, we'll move to you.
May it please the court. Good morning. I'm Doug Knott. I represent the defendants' appellees, Linda Thayer, Greg Scott, and Kayla Ziemba, as well as their employer, Advanced Correctional Healthcare. We're here to ask that the court affirm dismissal of the claims against those defendants.
Mr. Knott, do you mind if we start with Kayla Ziemba? Ziemba and whether or not she was being held out by Advanced Correctional Health as a clinical social worker able to provide this mental health diagnostic testing or what have you?
I don't know what policy Mr. Aiken was referring to. She is a qualified mental health provider, which is a defined term by a national organization called the National Commission on Correctional Health Care. And they have standards on mental health, and it defines in there what a qualified mental health provider is. It's in the record at docket 37-5 at page 2. And in there, it lists a series of professionals that can qualify as qualified mental health providers. Among them is psychiatric social worker, and then there's a catch-all that says others who by experience or training are qualified to perform risk assessments, suicide risk assessments.
But she was going a little further than a risk assessment.
I'm sorry?
Was she providing care beyond that of a risk assessment? I think an advanced social worker would be able to do that as well.
She was. She under Wisconsin law, and it's the administrative code, MPSW at 6.02 and 6.04, a advanced practice social worker is permitted to intervene in difficult situations. That under 6.04, a licensed clinical social worker is permitted to diagnose, treat, and a whole list of other activities that they can engage in, clearly providing therapy in a jail. And under Wisconsin law, Ms. Ziemba was not only acting under her certificate as an advanced practice master level social worker, but also was in training to become a licensed clinical social worker.
But going back to my question, I believe that ACH accepted below that Ms. Ziemba in this instance was providing licensed clinical social work services. And so I'm trying to tie up if she could do the risk assessments, but she was doing more here, and the allegation is deliberate indifference. What would have qualified her, I guess, under that training or supervision that I can go to in the record to demonstrate that she could, I guess, exercise that function?
I think she was acting, she certainly was qualified under, as the court observed, she was qualified under Wisconsin law to practice licensed clinical social work. The plaintiffs have never articulated a standard.
But see, that's where I think I disagree with that finding. When we look at Wisconsin law 457.04, one of the prohibited practices is engaging in licensed social work and not being supervised by or a licensed social worker. So I'm looking for the tie-up.
And she was supervised. We proposed as fact at record 74, paragraph 111, that she was supervised by a doctorate level clinical psychologist, and that was not disputed.
Would Dr. Caldwell, though, qualify under this statute?
Yes, and that's explained in Ziemba's affidavit that was submitted, that's record 40. And she explains, Ms. Ziemba does in her declaration, that her hours that she put in at the Vilas County Jail were submitted to the state for her approval to become a licensed clinical social worker. And
I guess where the disconnect is that there's nothing on the record that shows that Dr. Campbell could stand in the shoes of Dr. Caldwell could stand in the shoes of a licensed clinical social worker under the prohibited acts. Where you're talking are more so focused on what would have eventually qualified Ms. Ziemba as a licensed clinical social worker. What I'm wanting to direct us to is where in Wisconsin law could she act as a clinical social worker while being supervised by a psychologist?
I believe that we get into the weeds in the exact description of how the supervision occurs. I believe that's 457.08 sub 4 and then the paragraphs below there explain how that supervision occurs. And a doctorate level clinical psychologist is approved, and ultimately was approved in Ms. Ziemba's case as a supervisor. But to go back to your first question, I think that the question is whether Ms. Ziemba was, well, one is whether she was acting within the scope of her authority, which given the information that was provided to her, she certainly was. Whether it required a clinical intervention or the assessment and of a advanced practice social worker, what she performed the initial risk assessments. She saw Donna Christensen 4 times in 2 weeks, and after she performed the initial risk assessment, it wasn't support and some kind of fuzzy help. It was they worked on self-worth. But most importantly, she worked with her and counseled her on drug recovery. And
It's not clear from the record, but you could explain who made the determination that she could come off of, Donna could come off of suicide watch.
Ms. Ziemba did on the basis of her assessment on October 8th. And Mr. Aiken's reference to PA Scott is off the mark. Mr. Scott did not need to do a medical evaluation. He was just acknowledging that he's aware that she came off of the watch.
Can we need to go back to Ms. Ziemba. Let's assume she's qualified. She had in her arsenal knowledge of Ms. Christensen's past mental health issues and suicidality, because she had prior knowledge of Miss Christensen. She had previous experience with her from months before when she had been at the jail. So when you marry that prior knowledge with what Miss Ziemba is telling her in that first encounter about her hallucinations and thoughts of self-harm, and you also marry that with the fact that she's withdrawing from drugs, what are we to make of that within a minute's worth of assessment, she takes her off suicide watch in one day?
I don't think
why is that not a reasonable thing that Mr. Aiken is asking us to look at?
It's more than that. First of all, there was a suicide assessment mechanism. There's a questionnaire called an ASQ that was used, which is within her professional judgment. But beyond that, on October 8th, she, in her interview, Ms. Ziemba learned that Donna had self-insight that what she had been going through and what made her, she said, spaz out was a concern about withdrawal. And Ms. Ziemba was assured on the 8th that she was past that. But she came back on the 12th to make sure of that and did a long telemedicine, because it was COVID, did a long interview and came back again on the 20th to make sure that she was doing well. So the most important thing that she did as a social worker was implement a safety plan. That's the plan that was put in place, was to keep close watch on her, make sure she was articulate, make sure she was asking for her needs, and she did. She ultimately...
I'll be honest, one thing that concerns me is when Ms. Ziemba first sees her and tells her, I'm going to put you on suicide watch, Ms. Christensen's reaction is, I'm not going to talk to you then. As in, I'm not happy with this decision to be on suicide watch. So then Ms. Ziemba shows up the next day, and all of a sudden, Ms. Christensen is reporting, I'm cured, I'm fine. So when the court is drawing inferences from the record about what happened and the quality or the depth or scope of Ms. Ziemba's care, one issue there is whether Ms. Christensen determined she had to say whatever she needed to say when Ms. Ziemba shows up the next day to make sure she gets off suicide watch. And if that involves reporting that I'm no longer feeling the way I was feeling the day before when you told me you were putting me on suicide watch, that becomes an inference that it could be reasonable for a fact finder to draw.
it's a very troubling circumstance where the mental health provider is trying to assess whether the client is in fact misleading them to get off a suicide watch so that they could do that. On the other hand, she also knows that it's very uncomfortable, and as this court has acknowledged, it's very uncomfortable to remain on suicide watch, and so she's trying to balance that. But I think the important thing is to recognize that from her last statement that she had a mental health concern, the next day she had insight, and my client did know her from when she was a child. She had worked with her in the child welfare system, and there was no activity, there was no suggestion in all of those contacts from October 8th to October 26th when she committed suicide. There's not a single fact that suggests that she was delusional, needed care, that she was asking for help. There's not a single fact to that effect. And that's why it would not be a fair inference to suggest, particularly under the Eighth Amendment, that Ms. Ziemba should have inferred on the 8th that she would be eminently suicidal or that she would commit suicide 18 days in the future.
Thank you very much, Mr. Knott. We'll now move Mr. Jones to you.
Good morning, and may it please the court. I'm going to start, if I may, where you did, Judge Brennan, with the question about the claim against Sergeant Wilmot. That is, whether there are separate standalone claims, excessive force due process, or whether it's part of one larger theory. And I would say it's been both at times in this case. But to me, the answer is the same, whether they're considered as individual claims or part or wrapped up in one larger claim against Sergeant Wilmot. I think the record is clear on the excessive force component, principally pointing the court to the video recording, as Judge Peterson found, that speaks for itself, and it points to an absence of excessive force on Sergeant Wilmot's part. And considering that under, with the factors that the cases say are relevant, he had a good faith reason to use the force he used to pull the mattress from the cell, to hold Ms. Christensen against her bunk only briefly. He had a good faith reason to do both based on what was occurring in the cell. The amount of force he used was reasonable in relation to what was occurring.
If we, having reviewed the video, come to a different conclusion about whether it conclusively shows that Ms. Wilmot shoved him in a way that would make his return force proportionate, then do we then have a jury question?
I think ultimately the answer to those factors, that is whether he had a good faith basis to use the force, whether the amount of force was reasonable in relation to its purpose, whether he tempered the use of force, and whether there was injury or pain that was caused, stand independent of the question of whether Ms. Christensen pushed Sergeant Wilmot. So I think the answer is the same, even if the court has a question in its mind about what that video exactly shows. Because even if she hadn't intended to push him, there's still physical contact between the two of them. There's still the larger context of what she had been doing in the cell. So holding her briefly for less than 10 seconds against her bunk without using any additional force, I think under the circumstances was reasonable. And I don't think there's any evidence that it was done maliciously and sadistically for the purpose of causing harm. So I think the answer is the same, Your Honor. As to the due process claim or component, Your Honor asked the question, why is there a due process constitutional violation from putting her in disciplinary segregation for 10 days? And I think the answer is that there isn't. I'll come back to that, but outside of those 10 days of disciplinary sanction, Ms.
Was there an
Christensen's,
overlap between, because I think this is still during COVID, and so there's still the 2-week.
yes, there is an overlap, and that timeline is important, because when she was on COVID quarantine, or when she was in medical segregation because they were waiting for a test, and then when she was, after she came off the discipline, and was simply there based on her classification status, those are administrative decisions that the case law of this circuit says are not subject to due process concerns. For that 10 days, from October 6th to October 16th, 8 of those days she was still on a COVID quarantine. So her status really wasn't any different being on discipline, except that she had privileges removed. But the fact that she was in her cell for 23 hours each day, that would have been the same whether or not she had been on discipline, except for October 15th and October 16th.
But can you address Mr. Aiken's point that not only were there those 2 days after the COVID hold, she's in these 2 extra days of the 10-day, but also, according to Ms. Christensen, he tricked her or failed to mention to her that there would be 20 extra days. So now we're talking 15, 16, up through the 26th. She's still in the same posture now, regardless of COVID. Can you address that? Because that's what his answer was to Judge Brennan about the due process concerns. That is situation, and then also signing off on his own discipline. Those 2 things.
So a couple of things, or I guess to sort of unpack that. For those last 10 days, when she was confined based on her classification status alone, the circumstances weren't the same. Yes, she was still in a cell for 23 hours a day, but she had all of her other privileges returned. She had access to mail, reading materials, television. She was able to have contact with family and friends, both over the phone and via video means. So the circumstances weren't entirely the same, but the issue of Sergeant Wilmot tricking her or not, there's an audio recording of that conversation that's part of the record, record 5932. Sergeant Wilmot, as plain as day, asked her, "Do you want to appeal it to the next shift or accept it?" And Donna responded, "I'll accept it," and then signed. This idea that Sergeant Wilmot tricked her.
No. I'm aware of that part of the record. I'm aware that she chose not to appeal it to the next shift. I'm asking about under her understanding that this was not just 10 days, it was actually 10 plus 20.
Well, in part I would.
Because I don't get that from that exchange.
Well, there's, in part I would say, to accept Mr. Aiken's argument there is to accept that there's an affirmative duty on the part of the officer under the Constitution to explain all aspects of what the discipline might entail. And I'm not sure that the cases point to that. I'm sorry, I lost my
Except
train.
doesn't he kind of do the opposite? Because he says when your COVID test comes back, I'll put you by people, and that's actually not going to happen because she's got 10 plus 20 days of isolation left?
Well, in fact, that's exactly what happened, because her COVID test came back on October 8th, and as a result, she was removed from medical segregation and put in the D block where there were other inmates. So she was taken from medical segregation where she was entirely by herself and put in a housing unit or pod where there were other inmates.
That was still segregation, though, because she was her cell 23 hours a day, correct?
Yes, but
Yes.
that's not inconsistent with saying you're going to have 10 days of discipline, which she would have understood, and there was even part of that conversation that made it clear she understood, that means you're going to be in segregation for those 10 days in your cell 23 hours a day. But she was in a cell block where when she was out of her cell, she was able to converse and communicate and interact with other inmates in the cell, and there were other inmates not in the cell block, and there were other inmates in the cell block.
Thank you, Mr. Jones. Mr. Aiken, we'll move back to you now. 2 minutes for rebuttal.
Thank you. This case presents a very important issue related to mental health, which is becoming an epidemic in our country. Jails are now the biggest provider of mental health services, and particularly to those who are in the most vulnerable segments of our population. Donna Christensen was part of one of the most marginalized groups in our country. She's a Lac de Flambeau Indian, where drug use is rampant and there's a lack of access to traditional medical care. In fact, 45% of the inmates in Vilas County Jail are from her tribe. Deliberate indifference, the standard is evolving, and it's about decency and human decency. And paying lip service to the right to provide medical care for serious mental illness, support and encouragement instead of medical evaluation and treatment, a signature of a doctor instead of actually having a doctor evaluate the person, is not conforming with the standard of decency. It's not treating Donna Christensen like a human being, despite that she's from a marginalized group. And society has an obligation to do better. And the Constitution provides that guarantee for people like her. Ms. Christensen has a right in this factual record to move forward with her 1983 claims. This court should address those issues to move this litigation forward to the extent the record allows it. The procedural aspect of this case also needs to be put on its tracks. So there's two good reasons for this court to reverse the summary judgment from the district court, remand this case for full discovery, and allow the full evidentiary record to be presented to the jury to see what they think of her treatment at the Vilas County Jail and whether it conforms with the standards. And also, we would request that the state law supplementary claims that were dismissed without prejudice also be reinstated. Thank you.
Case will be taken under advisement. We'll move now to Appeal 24-1056, Philadelphia Indemnity Insurance Company et al. Versus Kinsey and Kinsey Incorporated. And Mr. Zudima, we'll begin with you.
Thank you, Your Honor. May it please the court. This case is procedurally complicated, but legally straightforward. The only issue the court has to decide is whether Kinsey's insurance policy covers the state court's judgment for breach of contract. Kinsey and its insurer agree that
Do we mind if we start at the two arguments at the kind of the lower end, though, the double recovery? Is that reviewable by this court?
Yes, I think it is, Your Honor.
And why?
I think this goes to the waiver issue. I'll just point out that Kinsey argued this issue more than once in the district court, including in the briefing on the motions that were resolved and are now on appeal. I'll direct the court's attention to docket 60 at page 2, as well as docket 12 at page 8 to 9. Both those briefs specifically.
Docket 60, I thought you had conceded that you only raised it in your TRO motion. So has that changed?
We didn't concede that, but I admit that we did not cite docket 60. I realized that as I was preparing for this oral argument. So we did actually cite it. This was in response to the other party's cross motions.
So I'm going to ask again, did you concede, though, that you only raised it? I know you're raising docket 60 now, but before, were we only looking at docket 12?
That was the only one cited in the brief. Oh. Yes, Your Honor. I apologize for that.
All right. And so why are we able to review it now?
We're able to review it because I think it was adequately preserved in the district court. This concept of double recovery sort of permeates this case. That's what it ultimately comes down to, is whether Bellin should be able to recover again for what amounts to the same injury for which it already recovered from the settlement. I'm happy to address this double recovery issue more if Your Honor would like. I'd really like to focus my time on the language and the purpose of the policy.
And what about the reservation of rights, the equity argument? Is that one waived as well?
No, Your Honor, that's not waived.
And so seeing that Philadelphia Indemnity agrees that the policy should apply, why would the reservation of rights argument apply in this instance?
Your Honor, the district court dismissed the argument in a footnote because Philadelphia Indemnity is not contesting coverage. But that, to me, really proves the point. The policy is a contract between the insurer and its insured, and they both agree that it covers the judgment. The only one who disagrees is not a party to the contract. And so if anything, that suggests that the policy does, in fact, cover the judgment, because that's how the parties to the contract agree, interpret it. But in any
doesn't
event,
the estoppel argument only come into play if the insurer disputes coverage?
if I missed the last part of your question.
If the insurer disputes coverage, isn't that the only instance where estoppel comes into play?
If we raised it as an estoppel argument, that's when it would come into play. But I think it's more than an estoppel
In
argument
any
here.
Illinois case, any Illinois court, have they employed this reservation of right argument when the insurer is not contesting?
Not that we found, Your Honor.
All right, so let's move to the wrongful act and walk our way through.
Happy to, thank you. The district court, just to back up and look at the big picture, the district court held that the policy does not cover the judgment because the policy covers only negligence and it excludes all claims for breach of contract. That narrow reading of the policy defies its text. It overlooks the basic purpose of an errors and omissions insurance policy, and it makes the policy all but meaningless to a small business that conducts all of its work pursuant to contracts. The end result, as I indicated, is that Bellin gets to recover $1.75 million for an injury worth less than half of that, and Kinsey might as well have had not have had any insurance at all. I'd like to focus on the grant of coverage first and then turn to the exclusions, which is how courts typically approach insurance contracts. The policy covers any wrongful act, which is defined to include a negligent act, error, or omission committed in the rendering of professional services. The district court read this to mean it covers only negligent acts, negligent errors, and negligent omissions, and that the judgment was not covered because it was not based in negligence. The district court erred in both respects. First, coverage is not limited to negligence, and it's key, I think, for the court to remember that in interpreting an insurance policy like this, the court must construe it as a whole, take into account the type of insurance and the nature of the risks involved, and the overall purpose of the contract. That's how this court described it earlier this year. The Bellin's brief calls the policy a standard errors and omissions policy, and that's exactly right. And the purpose of a standard errors and omissions policy, again, as this court explained in the Crum decision, is to ensure members of a particular professional group from liability arising out of the special risk such as negligence, omissions, mistakes, and errors inherent in the practice of the profession. Under the most reasonable reading of the policy, in light of its purpose, it covers not only negligence, but also errors and omissions that might not meet the legal definition of negligence, although I'll note they probably often do.
I'm wondering how your reading doesn't lead to moral hazards. If intentional errors and omissions are covered, an insured could just decide to stop performing on a contract, knowing that their insurance company will be on the hook to defend them if they are ultimately sued, even if their behavior was dishonest.
A few responses to that, Your Honor. First, I think the policy as a district court construed it incentivizes perverse outcomes because it covers negligence. A company is indemnified for its carelessness, but not when it makes actual honest mistakes, even despite due care. And that does happen. I'm sure it happens all the time. It's that something goes wrong in a big project, even though you did everything you could to prevent anything from going wrong. And so that, to me, is what the Supreme Court calls a contextually implausible outcome. Also, errors and omissions are not defined by the policy, so the court construes them under their ordinary meaning. And I don't think anybody construes a word like error or omission to mean a deliberate, intentional, deliberately wrongful act. I think most people recognize that it means an accident, something that you didn't mean for happen. You made an error, you made a mistake.
Is this the best case to make that argument? There's certainly a whiff in the record that global HR did not get installed, maybe because of negligence, but maybe not.
Your Honor, I think, and that leads me right into Bellin's argument, which is that this was a knowing, deliberate breach of the contract. I'll start by just making clear the trial court did not make...
Before we move, do you mind answering the question that Bellin does raise, and that's this contention that the argument regarding the proper construction of wrongful act was not raised below? that this argument is also waived?
Well, Your Honor, the district court based its decision on its interpretation of the policy under the pressed or passed upon rule. It was preserved because that was the basis for the court's decision, and we're allowed to challenge that on appeal. But turning to the record from the trial court, I just want to make clear that the trial court did not find that Kinsey knowingly, deliberately breached the contract. The district court didn't make that finding. The jury didn't make that finding. And I don't read anything in the trial court to support that finding. The trial court, when it directed its verdict, never suggested that it was finding Kinsey purposely or deliberately or maliciously breached the contract. And the jury, I'll note, rejected every claim that required any finding of intent, including punitive damages, including the fraudulent misrepresentation claim. But looking to what actually did happen in the trial court, the court acknowledged when it issued the directed verdict what it called the period of confusion surrounding Kinsey's obligations. It stated, quote, "There's evidence to support that." It recalled, and I'm quoting again, "The representative of Bellin asserted that the GHR module is too new," and it said it cannot draw the conclusion that there's no evidence that there had been conversations about that. And if you read the transcript, there's a lot of discussion that took place in meetings and on phone calls between Bellin, between Kinsey, the software developer, about what version of the software Kinsey was supposed to be implementing. There seemed to be confusion about the terminology that was used, because there was terminology for the broader project, there was terminology for the narrower module, there was a version 10, there was a version 11, and I believe the module itself was updated during all of this, and so the terminology changed. And I think it's clear when you read the transcript, and the trial court acknowledged this, there was confusion.
Is what you just said and referenced the reason for the Tomei agreement?
I'm sorry, I'm not sure I understand the question.
The confusion that you're talking about, is that the predicate for why this either Tomei or Thome agreement ended up getting negotiated?
Well, actually, Your Honor, I'm not sure why that got negotiated, because we weren't involved in it. Kinsey was not involved. When we found out about it, we objected to it, because the insurer, in its view, maxed out the policy on a settlement that we had nothing to do with. So I hope that answers Your Honor's question.
Thank you.
And that was during trial?
That was during trial. That was after the first week of trial over the weekend. And then I'll note the first thing they did on Monday morning is dismiss the negligence claim. And so we were left, Kinsey was left without any coverage for the rest of the trial. But in any event, I want to discuss the series modifier canon. That's what the district court relied on. First, I'll point out that the court never once addressed the purpose of an errors and omissions policy. It never addressed the types of risks that the insured is trying to insure against when it purchases a policy. It relied on the series modifier canon. That canon applies most forcefully when it would be odd to apply the modifier to only the first item in a series, when it would result in a contextually implausible outcome. And to address Your Honor's question from earlier, there is nothing implausible about a policy that covers non-negligent errors and non-negligent omissions, as well as negligent acts. That would not mean the policy would cover deliberately wrongful conduct, because I don't think that's a reasonable interpretation of the phrase error and omission. And even if those words could be construed that way, we have exclusions. The exclusions here specifically exclude deliberately wrongful conduct, like dishonest, fraudulent, criminal, malicious conduct, and knowingly wrongful acts. And so we don't think that's...
How does that dovetail into your argument regarding exclusion A?
Exclusion A, Your Honor, again, we think Bellin's reading of exclusion A results in a contextually implausible outcome, because under Bellin's reading, the policy covers only negligent errors and negligent omissions. The exclusion excludes errors and omissions that are dishonest, fraudulent, etc. And then the policy says nothing at all about the errors and omissions that the insured is most interested in insuring against. The whole reason it bought the policy was that it knows mistakes might happen even if they try and do everything right, and they use reasonable efforts. That, to me, again, is a contextually implausible outcome. And I'd like to reserve the remainder of my time.
You may do so. Thank you. Mr. Brown, we'll move to you.
morning. May it please the court. This case is not an insurance coverage dispute between an insurer and an insured. It's about a set-off provision in a settlement agreement. Under that provision, Kinsey is entitled to set off only if Kinsey's professional liability insurance policy provides coverage for the judgment arising from Kinsey's knowing breach of contract. This insurance policy does not cover wrongful acts committed knowingly. It doesn't even cover contract-based liabilities at all. It is limited solely to negligence. Without evidence in the record of negligence, and there is none, there can be no coverage, so there is no set-off under the settlement agreement. The district court thus correctly found that there is no coverage, so there is no set-off. It was right for at least 3 reasons. Number 1, Kinsey's liability arose from a breach of contract done with knowledge that it was a wrongful act, which means coverage is excluded. Number 2, Kinsey's insurance policy covers only negligent acts, negligent errors, and negligent omissions, and there was, as the district court put it, not one crumb in the state court's analysis to support negligence. And number 3, nothing outside of the policy compels or even suggests a different result, and this court should affirm. On my first point, though the district court did not rely on exclusion FF in its ruling, I think it makes sense to start there because everyone, even Kinsey, agrees that there is no coverage for a wrongful act done with the knowledge that it was a wrongful act. So let's get into the facts. Kinsey contracted with Bellin to implement a software called Global HR, but Kinsey didn't follow through and do it. The record in this case shows that while this 15-month-long software implementation project was still underway, Bellin learned that Global HR was not being implemented. Bellin then confronted Kinsey's president, Brad Kinsey, to demand that Kinsey make good on its promise. But he refused and demanded over $136,000 of additional compensation above the contracted amount, and in addition to the over $1 million that Bellin had already paid to have Global HR be implemented. That was the breach. The project was in flight. Kinsey could have still performed and avoided breaching the contract entirely, but decided not to. Kinsey made a business decision. It chose not to follow through on the services it promised to deliver for a fixed price, knowing full well it was obligated to complete those services under the contract.
Can I interrupt you? And I do want you to go back on the train you're on. I take it from your presentation right now that you're saying for us to determine the relevant coverage, we should and could look beyond the mere fact that the state court found for Bellin on the breach of contract claim, look past that to the underlying events.
To the proofs at trial, Your Honor, yes.
Or can we just look to the actual judgment?
Yeah, Your Honor can look to the judgment, to the state court's analysis to the judgment, and to the proofs at trial, I believe, is the standard for analyzing the duty to indemnify after a judgment has been entered.
Okay, because you're going through the proofs at trial.
I am, Your Honor.
But it may not be necessary.
It may not be necessary, but I think the facts are very strong under the circumstances here, and they're kind of swept under the rug by Kinsey's presentation, and so I'm trying to bring them to the fore.
Okay, thank you.
So this resulting knowing breach of contract was done with the knowledge that it was a breach, so the resulting liability falls squarely within exclusion FF, and there is no coverage. To be clear, this was not an honest mistake, as Kinsey would now have it. Let's compare the undisputed facts here to the honest mistake example from Kinsey's reply brief. So in that example, a contractor is hired to pour concrete, is handed a contract with a misprint that makes the start date of the project look like May 1 instead of May 7. He goes to the job site on May 1, pours the concrete, and ends up causing all kinds of damages. To make that hypothetical work for this case, it would be that the concrete guy went to the job site on May 1, but there's a project manager there saying, hey, we're not doing this on May 1, we're doing it on May 7, don't pour the concrete, and the concrete guy pours it anyway. That's precisely what we have here. It's not an honest mistake. Kinsey tries to avoid exclusion FF by obfuscating the record, claiming that there was some kind of confusion about whether Global HR was supposed to be implemented. While any purported confusion would not make this a covered claim under the policy regardless, it still merits dispelling this myth to explain why exclusion FF plainly applies. The record here shows that Kinsey's president, Brad Kinsey, knew exactly what he was required to do under the contract. In fact, Kinsey's trial counsel in the in the Wisconsin trial, on the record, had to admit that Mr. Kinsey was never confused about his company's obligation to implement global HR. Now recall that Kinsey and Mr. Kinsey were on trial for fraud. Confusion would have been quite helpful to their defense. So if their trial counsel could have pointed to evidence of Mr. Kinsey's confusion, he certainly would have, but he couldn't, so he didn't. This claim of confusion is nothing but a red herring. Kinsey also points to the jury forum, where the jury rejected a finding that Kinsey acted maliciously or with intentional disregard for Bellin's rights. This argument fails for two reasons. First, setting aside that this section of the jury forum was about punitive damages, which are irrelevant to a breach of contract claim, malice or intentional disregard of rights is not what triggers exclusion FF. It requires only knowledge. And on that point, the record is clear. Kinsey knew that it was not implementing global HR and that it would breach the contract not to implement it, but it still chose not to do what it had promised. The second is this court's ruling in Baylor. There, the court drew a sharp line between an intentional breach of contract and some kind of bad faith motive. And a bad faith motive is what the jury was asked about here. Kinsey's motive or mindset in breaching the contract, as the court held in Baylor, is irrelevant. Moving on to exclusion H, and this one the district court did address and correctly found that it applies. That provision excludes claims arising out of any express warranties or guarantees or any liability you assume under contract unless you would have been legally liable in the absence of such contract.
What do you do with the argument this morning that it was unclear what the requirements were under the contract?
So Mr. Kinsey was the president of Kinsey & Kinsey, and it's crystal clear on the record that he was never confused. The only confusion that was cited by Kinsey was the confusion of an employee of the software developer, a woman named Kathy Kath, who was an employee of Infor Lawson. She was perhaps confused about what about what Bellin wanted or what Kinsey was doing, but Kinsey and Brad Kinsey, there's no evidence of their confusion. So getting back to exclusion H, here the claim arose out of an express warranty that Kinsey made in its contract with Bellin to follow the agreed upon statement of work and implement global HR. Kinsey tries to avoid this one by arguing that assume does not mean what the dictionary says it means, which is to take to or upon oneself. That's the first definition in Merriam-Webster. And it says nothing about taking anything from third parties. And let's think about the extraordinarily common phrase, assume the position. That doesn't talk about third parties, and it's one of the most common uses of the word assume. So here, you have no liability, then you take one on pursuant to a contract. That is excluded. In addition, the verb assume in exclusion H does not even apply to express warranties under exclusion H. The policy just excludes any claims arising out of express warranties. And in its contract with Bellin, Kinsey expressly warranted that it would strictly follow the statement of work, which included the implementation of global HR. So exclusion H applies 2 times over. The district court was also correct in ruling that this exclusion does not render the policy illusory. There is still plenty of coverage because the exclusion carves out legal liabilities that would have existed in the absence of the contract. That carve-out was missing from the Crum-Forrester case on which Kinsey relies and makes it distinguishable from the facts here. For example, the negligent misrepresentation claim that Bellin alleged but later dropped after the Tomei settlement, that would still be covered because Kinsey had a common law duty not to make negligent misrepresentations, not a contractual duty. Or say Kinsey had tried to implement global HR but ended up crashing Bellin's entire system due to negligence. That would still be covered. And let's not forget, the insurer paid out $1 million settlement on Mr. Tomei's behalf, based in part on his potential liability under common law for his misrepresentations. So there is coverage, just not for Kinsey's failure to perform on its contracts. Moving on to my second point. The district court also correctly ruled that there is no coverage because Kinsey's breach did not qualify under the policy's grant of coverage for wrongful acts. That is, negligent acts, errors, or omissions. There was no negligence that precipitated Kinsey's breach. Indeed, as the district court concluded, there is, quote, not one crumb in the state's court's analysis supporting the idea that the court thought that the breach of contract occurred due to negligence, end quote. In this appeal, Kinsey has not identified any crumbs that the district court missed. because there are none. In making this ruling, the district court followed a long line of precedent, well over a dozen cases from state and federal trial courts and appellate courts around the country, that have consistently held that the phrase negligent acts, errors, or omissions means negligent acts, negligent errors, or negligent omissions. This interpretation makes sense. As several of these cases set forth, it aligns with the series qualifier canon. It also aligns with the rules of English syntax, under which a leading modifier, followed by a comma-separated series of nouns, modifies each of the subsequent nouns. It also aligns with the other provisions of the policy, specifically Exclusion A. That provision excludes claims arising from any dishonest, fraudulent, criminal, or malicious act, error, or omission. Kinsey admits that the series qualifier canon and general rules of English syntax apply to Exclusion A, that all of dishonest, criminal, or malicious modify each of act, error, and omission. The definition of wrongful acts in the policy is structured the exact same way. An initial adjective, negligent, followed by the same three nouns, act, error, or omission. These two provisions, within the same policy, with identical structures, should be interpreted the same way. It also aligns with this court's ruling in Baylor, which I mentioned before, where it was held that intentional noncompliance with a contractual obligation is not covered by an insurance policy that covers negligent acts, errors, and omissions, even if the noncompliance was done in good faith. In that case, on advice of counsel, there is still no coverage for knowing or intentional breaches of contract. Under a policy with identical language to the policy at issue here, motives don't matter, only actions, which cuts against Kinsey's position about an honest mistake even being covered in the first instance. Kinsey did manage to find 3 cases supporting its reading of the definition of wrongful acts: a Massachusetts state court case from 1995, a California state court case from 1958, and an Iowa state court case from 1993. These cases, all of them non-binding, are unpersuasive. The origin of these 3 outliers is Aitchison, the California state course from 1958. But this ruling was expressly based on the court's assumption, not an analysis of the phrase negligent acts, error, or omission. In fact, none of the parties, including the insurer, even argued that the word negligent modified errors or omissions. Instead, the court concluded that, quote, it must assume, end quote, that the word error would have its ordinary meaning unmodified by the word negligent. It did not cite the series qualifier canon. It did not cite the rules of English grammar and syntax. It did not contend with any arguments or authorities going the other way. This is not a persuasive case. The Massachusetts state case, USM v. First State, simply follows Aitchison, and again relies on the plain meaning of the word error without regard to the modifier, negligent, that precedes it. No mention of the series qualifier canon, no mention of the rules of English grammar and syntax, and no grappling with the host of authorities going the other way. The Iowa case, Employers Reinsurance v. Mutual Medical, made the same mistake, concluding, without any analysis at all, that negligent did not modify error or omission. That's it as far as cases that Kinsey cites in its favor that interpret the same phrase. Other cases it cites are parsing phrases with a different structure, such as error, omission, or negligent act, where the term negligent clearly does not modify anything but the word act. Those cases are irrelevant to this analysis. The cases on point that Kinsey cites, however, are true outliers. They fly in the face of interpretive canons and the generally accepted structure of the English language, and this court should not follow them. But this discussion is purely academic because Kinsey's argument rests on the notion that if it can rewrite the policy to remove the negligent modifier from error and omission, it can shoehorn Kinsey's contract breach into coverage as an honest mistake. But again, this was not an honest mistake. Kinsey knew its contractual obligations, had every chance to perform them, and chose not to. Now to my third and final point, Kinsey's other arguments that the policy is ambiguous, that the insurer waived coverage defenses by failing to issue a reservation of rights letter, or the belated assertion of double recovery, none of them warrant reversing the district court's ruling. The policy is not ambiguous, the words are clear and not reasonably susceptible to different interpretations. Moreover, and perhaps more importantly, the cases on resolving ambiguities against the insurer only arise in the context of insured versus insurer, which is not the case here. And I see that I'm out of time. Unless the court have any questions, I will step away.
No, thank you, Mr. Brown.
Thank you.
Mr. Zudima, we'll come back to you for rebuttal argument.
Thank you, Your Honor. There is coverage, just not for Kinsey's failure to perform on his contracts. That is how Bellin interprets the policy. That policy provides cold comfort to a small business who only performs business pursuant to contracts. And in every case where something could go wrong, will be sued in contract. That is not what Kinsey thought it was getting when it bought its insurance. It's not what anybody would think they're getting with an errors and omissions policy. It's not a contextually plausible outcome. The insured is left with a sliver of the coverage that he reasonably intended or reasonably expected from his policy. And I'd like to address, I did not get much time to address the exclusion, but that came up. I'd like to address exclusion H first, if I may. That was the basis of the district court's decision. Again, that would make the policy meaningless, especially when the economic loss doctrine might apply to contracts like this that would result in Kinsey only being sued in contract. And so in that event, the policy might as well not even exist. But setting that aside, the district court misread the exclusion. The exclusion removes from coverage any claims for liabilities you assume under contract. My opposing counsel cited Webster's online dictionary and nothing else. We cite several cases that actually interpret the word assume in a legal context. The contract does not say assume the position, it says assume the liabilities. Or it says assume under contract, rather. So we think the language of the exclusion is clear, and we think it was misinterpreted. If exclusion H does apply, it's illusory. The exclusion uses remarkably broad language. It excludes claims arising out of, resulting from, based upon, or in consequence of, directly or indirectly, any express warranties or guarantees or any liability you assume under contract. I can't imagine a broader provision. And it's certainly broader than the exclusion in Crum, which this court held, the exclusion in Crum excluded claims just based upon or arising out of breach of contract. That is a comparatively pretty simple provision. And there, the court held that even narrower language encompasses any claim that involves the contractual relationship. It's the same outcome here. As the district court recognized, Kinsey does not render professional services without a contract. So the policy covers only certain acts that necessarily involve the contractual relationship, and then it excludes all acts that involve the contractual relationship. That is the definition of an illusory policy.
Thank you very much,
Thank you,
Mr.
Your Honor.
Zudima. The case will be taken under advisement. Mr. CSO? Mr. CSO?
6.
The court will now call appeal numbers 23-3262 and 23-3343. This is Stewardson versus Titus and Biggs. And Ms. Schneeman, we'll begin with you. You may continue.
Good morning. The punitive damages imposed on Christopher Titus are grossly excessive and should be constitutionally corrected. Mr. Titus accepts the jury's determination that he is deserving of punishment, but we submit that his conduct was not so reprehensible that he deserves to be punished for the rest of his life by a debt that is so large and crushing that he is effectively sentenced to a lifetime of financial ruin. The $850,000 imposed on Mr. Titus is far more punishment than is necessary to achieve the state's legitimate objectives of punishment and deterrence. It is also utterly disproportionate to the punitive damages imposed upon law enforcement officers in cases involving far more egregious uses of force and causing injuries far more serious than those in this case. As the cases in the table provided in our opening brief reflect, juries in this circuit typically award...
Ms. Sheeman, can we first, though, look at those factors, those State Farm factors regarding
degree of reprehensibility?
Yes. Can we start there? Because I know we want to talk a little bit about those, because I think that's important, because I don't think that Stewardson engages with the cases in the Seventh Circuit dealing with punitive damages that are this large, but I wanted to go back, if we can, to Guidepost 1 and those State Farm factors.
Right. Yes, the degree of reprehensibility is something that the court must consider in determining whether the punitive damages imposed on Mr. Titus are unconstitutional. And we submit that reprehensibility is somewhat ambiguous. The facts of every case differ, and that is why it is important for courts, and it is a legal question for courts, to determine the constitutional maximum of a punitive damage award that is appropriate in any case. We submit to your honor, we're not here today to make excuses.
But what do we do with the Supreme Court giving us the directive that it's that factor?
Right.
Whether or not that conduct was reprehensible, that's the most important.
It is the most important, yes. But what we submit is that conduct can be deserving of punitive damages, but there are degrees of reprehensibility, right?
Right.
And that's why it's important for this court to take a look at the factors here, and also in those State Farm, BMV factors, the difference between punitive damages awarded by the jury in our case and by juries in other cases. And that's why I kind of want to bring the court back to that table that we submitted in our...
But I know where you want to start, but I want you to start with that conduct and walk through those factors and why that factor weighs in favor of lowering this particular award. I want you to, I know where you want to start, but that's where I'd like for you to start.
Right, Your Honor. Well, the Mr. Titus's conduct did not result in a significant physical injury to Mr. Stewardson. There was a 1-inch cut above his eye, for which he did not seek medical treatment after he was released from jail, just got some gauze pad when he was released in jail. This case involved mostly claimed mental and emotional injuries. Those are very intangible and difficult to prove. Obviously, Mr. Stewardson convinced the jury in this case through the testimony of his family and friends that he had serious mental and emotional injuries, the aggravation of a lot of his pre-existing mental and emotional injuries. But the fact of the matter is that when we look at this case in comparison to other cases in which punitive damages were awarded, the injuries to Mr. Stewardson were not severe. This is not like the cases where we have police officers who have punched citizens in the face, broken facial bones. This is not like cases where they have beaten subjects that have been restrained in medical wards, handcuffed to beds, causing serious injuries resulting in the need for surgeries. This is not like the case we cited in our brief where a police officer indiscriminately shot into a crowd of people, shot 3 innocent civilians, causing them multiple gunshot wounds. In all of those cases, the jury's awarded punitive damages, only a fraction of the compensatory damages. And here we have conduct that is not anything like the conduct in those other cases.
Why shouldn't we be more deferential, though, to the district court? They had a remitted or motion. The district court had a remitted or motion before it. The district court heard the evidence, saw the people testify, instructed the jury. Close questions like how much is too much for reprehensibility, that was determined by a jury, and the district court had all that in front of it, then yet denied the remitted or motion. Why shouldn't we defer to that call?
Your Honor, there's several reasons. One, the courts have a duty and legal obligation to consider the constitutional maximum of a punitive damages award.
And here we're at a 2.1 ratio. We're within what that normal ratio would be.
Well, arguably, yes. I want to make sure I circle back to your first question, but with respect to the ratio, it's important for this court to also observe that in typical cases, the majority of cases that we found in our legal research, the punitive damages that are imposed are a mere fraction, not twice or more than twice the amount of the compensatory damages awarded as they are here. And I want to make the point, too, that not only the United States Supreme Court in the State Farm v. Campbell case, but also this court, and I know it's cited in our brief, although I don't have it off the top of my head, has recognized that when the compensatory damages awarded are substantial, and they were substantial in this case, the award was $400,000. When the compensatory damages are substantial, the Supreme Court in, again, State Farm and this court have suggested that a ratio of 1 to 1 very well may be the constitutional maximum.
So if we were to pose to you the question of what's the limiting principle, how much should we as a federal appellate court cut down this figure, would your answer then be 1 to 1?
No, but I do suggest that 1 to 1 is something that the courts have suggested. We think that the court must take into consideration all of the factors, including the amount of punishment. Again, punitive damages are intended to punish the wrongdoer and send a signal to other people not to do the same thing, right? It's not intended to be a windfall for the plaintiff or extra damages, a bonus for the plaintiff. The plaintiff in this case has been fully compensated. What the punitive damages are supposed to do, again, is to punish the wrongdoer. What amount of punishment is appropriate in this case and the constitutional maximum? And we submit that a $50,000 punitive damages award is a very serious punitive damages award in this case, not only given the facts of this case, but also comparing the facts of this case to the facts of other cases in which juries have awarded punitive damages. The reason, in part, that this is such an onerous and oppressive and grossly excessive punitive damages award is because it imposes punishment on a young man who now is only 33 years old, but was even younger at the time, of modest income, that is going to financially burden him for the rest of
And,
his
and you
life.
chose not to present evidence of his financial situation, as was your right, to the jury. I want to move on to intervening, opportunity to prevent and intervene. Is your position that an opportunity to prevent or intervene for a supervising officer should be limited to instances where the officer is physically present during the use of force? And I'm asking that because didn't we hold in Yang that officers could not ignore their duty to prevent fellow officers, quote, who summarily punish a third person in his presence or otherwise within his knowledge, end quote. So I'd like you to address our holding in Yang.
Right, right. The cases that this court, the cases in which qualified immunity has been granted, and we're now talking about the cross appeal, but the cases in which qualified immunity has been granted and the cases which consider the duty to intervene, Yang holds that an officer must be present, a law enforcement officer must be present while the force is being used. And if this court is going to move away from Yang or establish new law that an officer who witnesses force on one occasion and then maybe there's another use of force by a fellow officer on another occasion in a different location, minutes later, hours later, where the officer accused of failing to intervene is not even present.
Can you address our language or otherwise within his knowledge?
Well, the use of force, the hip toss that's at issue in
That's
the
what I'm
cross appeal.
referring to.
Right, right. The hip toss was not within Officer Biggs' knowledge. He was not there. He didn't witness it, nor did he anticipate it. So now we can say in hindsight that the force Mr. Titus used when he shoved Mr. Stewardson into the wall or when he used his leg sweep to take Mr. Stewardson to the ground, the jury has decided that that was excessive force. But Mr. Biggs, while he witnessed those two things, did not necessarily see them at the time as an excessive use of force. But even assuming that he had, the bottom line is he was not.
Why would we have used that language in Yang if the duty to intervene or prevent is limited to punishing a third person in his presence, if it's limited to being present? What work is this phrase or otherwise within his knowledge doing?
Well,
Can you give me an example?
Well, I submit to you, Your Honor, otherwise within his knowledge can't be for trying to forecast the future, anticipate something that may or may not happen in the future, and prevent something in the future. But I want to also add that Section 1983 liability is premised on fault and based on personal liability. And it's difficult for us to reconcile that a person can have personal liability and fault for something that he or she is unaware occurred or is occurring. Mr. Biggs was not present when that hip toss occurred, and to say that failure to intervene liability can somehow be separated from an officer's presence or observation of the force while it is going on is essentially distorting the whole foundation of premise, the whole foundational premise for Section 1983 liability. The bottom line is Mr. Biggs could not have stopped or cautioned a hip toss that he wasn't present to witness or see was occurring. So I want to focus back on.
Or would you like to reserve the remainder of your time?
Oh, yes, I would. Yes,
Very good. Thank you, Ms. Schneeman. We're now, Mr. Keller, going to move to you.
Good morning.
Good morning.
May it please the court, I'm Duran Keller. I have the honor of representing Blake Stewartson, who is the appellee and also the cross appellant here. Good to see you again. So, Mr. Titus has said here that this is constitutionally excessive, that he didn't get due process. And if we look at what happened here, we had substantial discovery, we had a jury trial, they took the first appeal, used a lot of resources, a lot of depositions, and then got precisely what they wanted, a jury trial on all of these issues. Yet he says that he didn't get due process. And the main argument, well, let me start with what matters. The Supreme Court's guideposts. Reprehensibility, the ratio of disparity of harm, actual harm, and as compared to punitive damages. And then the least relevant is the comparable penalties. So, reprehensibility, the most important
So do you
factor.
engage?
Yes.
Do you engage at all with the third, the one that you said is the most or the least useful? The comparable cases?
Yes, would you like me to start there?
I would, because
Okay.
I don't see that you engaged with that in your briefing, so I question whether or not any argument that you present on that is waived.
And I appreciate that. Let me see if I can answer. Below with the district court and in
Is
the
your
court.
argument waived?
No,
Why not?
because the district court's order cites that the parties have each submitted many cases that are comparable, some lower than what they said, some higher. So no, I don't believe the argument is waived, but it also brings up a
Did
point.
you address it in your appellate brief?
I'll be honest, I don't remember.
You don't remember what you've disclosed in your briefing?
I don't remember whether we addressed the specific cases that we cited to the court below.
Do you recall if you addressed the third guidepost in your briefing?
I believe in our reply, which is the
In
last
your
brief.
opening brief, because we understand that new arguments cannot be raised in a reply.
Understood.
So to redirect you, did you raise this argument regarding the third factor, the third guidepost in your briefing to this court?
I don't remember. I'm sorry. I could supplement and look at the brief. I just don't remember. I apologize.
But to the extent that you raise the argument about this award is perfectly fine, that's different from failing to engage with certain cases in your brief. So I guess you have made the argument that the verdict should stand because it's perfectly within the guidance we've gotten from the Supreme Court. You've made that argument?
Yes, Your Honor, we did. Thank you.
So did you waive?
I don't believe that we waived because, and I promise I want to fully answer your question. You're asking if I've waived. I don't believe we did, but I can't tell you what was in that opening brief. I just can't. I'm sorry.
All right, so let's look at the third factor.
Okay. Here's what's important. We talk about comparable cases. Most cases don't go to trial. That's one of the problems with that third factor. We could cite a litany of cases I've had alone in the last 2 years that are at or above this amount. And so that's why this third factor. And then if you look at, I think the crime of murder in Indiana is like a $10,000 penalty. How could that third factor be huge? It's the smallest thing. Our case law has said that is not the biggest determinant here. So, I apologize that I can't give you a better answer on the third factor. I don't believe it's at all dispositive. I know the district court did rule that there were cases going both ways. And I'm sorry I can't do better than that. As to reprehensible...
Ms. Schneeman has offered $50,000 as a figure.
Correct.
The jury obviously went much higher than that. The remitted motion was before the district court. District court made a decision to deny the remitted motion. Is there something in the record that you see that justifies that smaller amount, or are you asking us to defer to the jury and the denial of the remitted?
I'm certainly asking the court to defer to the jury. I think that's paramount. Our courts have said that. The $50,000 number was just made up. But we know that. We can just say it now. It doesn't come from anywhere. If anywhere it comes from a Sacramento, no, that was a 1-to-1 ratio. It's made up. That's where it comes from. Ours is actually from jury who was well impaneled, well instructed, and deliberated, right? And we know that juries can come to different decisions. There are no two cases that are the same. I hope I answered your question.
You did.
Wonderful. As to reprehensibility, every single box is checked. Every single one here. You had physical, repeated contact. Mr. Stewartson, having the worst night of his life the love of his life had rejected him. He was drinking and driving, pled guilty to this. He gets slammed against the wall as soon as Titus gets a hold of him. As soon as he gets a hold of him, takes him to a cell, slams him down on the ground, right in the vicinity of everybody else. Then people are on top of him for 26 minutes. He has a strike. After they strip him naked, and when they finally leave him alone, the supervisor, Biggs, tells him to come back. Tells Titus to go back and deal with him. He didn't need to go in the room, and then that's when he gets slammed down again, right? There was a pool of blood. I take exception to this notion that there weren't severe injuries. But I don't want to waste my time on that.
On the failure to intervene, the initial failure to intervene that went to trial, at that instance, Mr. Stewartson was fully cuffed. The failure to intervene that occurred, that's still present in front of us, he has one cuff on and one cuff is off, is that correct?
I believe they were both off at this time. That's
Both
what,
off.
That's what my co-counsel is going to be handling.
Very good, thank you.
All right. Trying to figure out how to spend the remainder of my time. So they cited to the Sacramento case. That was some mistakes that were made in a mortgage. That's what they cite to as their loan authority for being a 1-to-1 ratio and saying it should be done here. But in that case, it said the difference is, they said it was reprehensible but not to an extreme degree. There was no physical contact whatsoever. It didn't reflect any injury to health or safety, and there was no evidence of malice. It's not anywhere near close to this one. What's a lot closer is the Rainey versus Taylor case from the Seventh Circuit from a month before in 2019. And in that case, they upheld a 6-to-1 ratio, which in this case, by the way, it could have been much closer to a 9.9-to-1. We'd be talking $4 million. That'd still be constitutional. In the Rainey case, it was a 6-to-1 ratio, $1.13 million in compensatory and $6 million in punitives. And that was upheld. They didn't want to talk about the case that was cited in the Sacramento case. That's a lot closer to this one, but this one's worse. Because in the Rainey case, you had sexual assault, and it was repeated. It was touching is what it was, in the vicinity at a club with everybody else. This is completely different. They chose not to bring anything up to the jury on his finances. We don't even know. There's no actual record evidence of any of this stuff because they didn't put it before them. They got due process, and I apologize. I'm saying that my time has run out. I hope that I've answered the questions, and thank you all for hearing us.
Thank you very much, Mr. Keller. Mr. Harris will now move to you.
May it please the court, I'm Marty Harris. I also represent Mr. Stewartson. I'll start by answering your question, Judge Brennan.
Thank you.
At the time of this failure to intervene, both of the handcuffs were off. I don't know if you have any follow-up on that.
No, but thank you for that clarification.
Okay. The district court made 3 errors at summary judgment in 3 different buckets. There was the failure to intervene bucket, there was the excessive force bucket, and there was the Monell custom bucket. For the failure to intervene, the error was the district court ruling that no reasonable person would know to intervene against Officer Titus's brutality at the time it was happening in order to protect Mr. Stewartson from further brutality. For the excessive force, the district court did not analyze the amount of force that Officer Biggs had used, which Officer Biggs admitted was the maximum amount that he could muster. Also for excessive force, the district court did not analyze the individual uses of force. Instead, it erred by concluding generally that Mr. Stewartson had, over a period of time, been uncooperative, disruptive, and threatening. Those things were jury questions, not questions for summary judgment. For the Monell custom, the district court erred by not considering the existence of the custom and then by concluding with ambiguous evidence that Mr. Stewartson was suicidal. Therefore, his being stripped and strapped was constitutional. Those were jury questions, not questions for summary judgment. So I'll start with failure to intervene since it seems like that is what this panel was most interested in. The clearly established law is that if an officer does not take a reasonable opportunity to at least warn a fellow officer from committing excessive force, then they're both responsible for later excessive force.
That puts the second officer in a very difficult position, though, because any time they'd interact with anyone who was under arrest, they'd have to give a warning then. They can't see the future.
Obviously, they can't see the future, But if they're involved in an arrest where excessive force is being used, which is the situation analogous to what we have here, the absence of a warning at that time to stop using excessive force, the absence of a warning in the next half hour to stop using excessive force, which then immediately leads to more excessive force, that's the situation that we're dealing with. It's not
But
a lawful arrest.
I thought
sorry.
this was a little factually different with the excessive force, and maybe I'm conflating the two, and so help me. As far as with the excessive force with Deputy Biggs, I thought it was the knee strikes.
The excessive force with Deputy Biggs is the knee strikes. That's bucket number 2
Okay.
of the cross
I
appeal.
wanted to make sure, okay.
Yes.
Okay, and the failure to intervene here is when Deputy Titus does this, what I'm calling the sweep.
I believe in the district court, the sweep referred to his being thrown to the floor initially.
Okay.
And that we're talking on this appeal about what was called the hip toss.
The hip toss, that's,
Yes.
so I'm using the wrong term, so yes, we're the hip toss, okay.
Yes.
And where you're going is that by the time Biggs sees Titus slam him against the wall and do a leg sweep, at that point, whether or not he can guess that a hip toss is coming down the pipe next, under your theory, he's obligated under our case law to then warn Titus, hey, no more excessive force.
Regardless of whether Biggs knew a hip toss was happening, he did have the obligation at that time, the wall slam, the second wall slam, or the throw into the floor. At that time, his duty to intervene arose. He didn't,
Based on the 3 things he had seen before.
the 3 things that he had seen before put him on notice that there's a need to protect Mr. Stewardson from Officer Titus. He didn't take advantage of that opportunity.
Is there a clearly established case law that says that?
Yes, the clearly established case law is Yang, which is cited in our brief. It's Lanigan, which is cited in our brief. And when this case first came up on appeal 2 years ago, Judge Jason Kumi and Judge Pryor, you both ruled that the question of whether there is a reasonable opportunity to intervene is a question for the jury.
For the court ruled, right?
The court, yes, the court ruled. Both of these judges were on that previous panel, and in that ruling, there was a decision that 30 seconds between the second wall slam and the being thrown to the floor, that created a jury question as to whether there was a reasonable opportunity for Officer Biggs to tell Officer Titus to stop, to tell Officer Titus to not do that again, to correct Officer Titus's misconduct. If there's a jury question of that in 30 seconds, how could there not be a jury question of the additional 30 minutes that Officer Biggs had as an opportunity to tell Officer Titus, this is unacceptable, this is not what we do as officers, to then turn around and send Officer Titus back into that room alone with Mr. Stewardson without any warning, without any intervention. A jury could determine that it's reasonably foreseeable at that point that since every single time that Officer Titus interacted with Mr. Stewardson that night, excessive force occurred, that excessive force would occur again absent that warning.
The case law seems to admit of a major difference, though, between an individual who is handcuffed and not handcuffed.
I agree that I think that is more towards the excessive force reasonability analysis as opposed to the failure to intervene analysis. The failure to intervene analysis is dependent on, do you have reason to know that you need to intervene? Did you or did you not intervene? And did further violence occur? That's the Lanigan case, and the reason why Lanigan went in favor of the officers is because in that case, there was no further violence alleged. Here we do have the further violence. And so I hope that answers your question.
It does.
Okay. It's also important to note that for the failure to intervene here, Officer Biggs is the supervisor of Officer Titus. That is, officers have a duty whether or not they're supervisors, but here he was a supervisor, and in his supervisory capacity, he sent Officer Titus back into that room without the intervention that was necessary. I see that I have a minute left, so I want to just quickly on excessive force. Our argument is that there is waiver by Mr. Biggs as to the amount of force used. That was never argued in the district court. It wasn't even really argued here on appeal. There was no analysis of the amount of force used in the district court. The district court's decision generally concluded that it was reasonable to use force at some point, but it never identified what that point was in the 26-minute video, which is part of the record here. I think, so excessive force needs to be remanded on that basis. And on the Monell custom, there was no analysis of the district court of the existence of the custom. Deputy Titus's testimony establishes a custom. He was questioned specifically, suicidal or not, somebody doesn't comply with the strip search and intake procedures, their clothes are coming off right. Deputy Titus agrees with that. There could not be a better lay definition of a Monell custom than what came out of Deputy Titus's mouth, and that custom resulted, as argued in the brief since amount of time, in Mr. Stewardson being stripped at least as a jury question. Thank you.
Thank you, Mr. Harris. Ms. Schneemann, we'll move back to you.
Thank you. I want to start with the last thing that my opposing counsel said. The plaintiff has mischaracterized the testimony. I think if the court looks at docket 111, the district court 111-4, Christopher Titus's testimony on page 194 through 195, Mr. Titus was explaining that if you come into the jail and you don't allow yourself to be subjected to a pat-down, and then you refuse to voluntarily change into an orange jail uniform, the officers will remove your clothing for you. Mr. Titus was explaining that it's important to make sure that drugs, weapons, and contrabands don't get into the jail. And if the court looks at that testimony, it will see that Mr. Titus did not say anybody who comes into the jail and is not cooperative with the booking process is going to be stripped naked and put in a restraint chair. That is an inaccurate summary of the testimony. Also, with respect to the excessive force, the plaintiffs are trying to send back to the district court the 2 knee strikes performed by Cameron Biggs. Cameron Biggs testified, if the court looks at docket 111-3, pages 49 and 50, Mr. Biggs was testifying about how peroneal knee strikes are performed in general. He said you basically
Are we able to look at that testimony if this was dismissed on summary judgment?
Well, this was the testimony that they cited in their motion for summary judgment. They only gave the district court the page and line numbers. They did not discuss the testimony. I see that my time is up. May I finish?
You may finish your thought.
Yes. I think it's important for the court to look at what Mr. Biggs actually said, because the question put to him was, can you describe the physical motion of performing a peroneal knee strike? And he did. Basically said, you swing your leg back. Then the follow-up question was, do you strike with all your available strength? He said yes. There is no testimony. The plaintiffs did not submit any evidence to the district court that the force used was too much. Mr. Stewardson didn't even offer to the district court that the peroneal knee strikes hurt, that he had a bruise. There was no evidence that they contested the force.
Thank you, Ms. Schneemann. Thank you, Mr. Harris. Thank you, Mr. Keller. The case was taken under advisement. The court's going to take a 5-minute break. We'll continue with case number 4. This is Appeal 22-3068, Wilson versus Castaneda. Mr. Lindiger, let's begin with you.
Thank you, Your Honors. May it please the Court, good morning. My name is Michael Lindinger, and I represent the plaintiff, appellant Malcolm Wilson today. Your Honors, this case boils down to a simple equation. Does the statement, was later sent to an outside hospital for his injuries, plus the statement, he was doubled over in pain, equal up to $100,000? As set forth in Wilson's briefing, the answer to that question is no. Disciplinary hearing Castaneda did not provide any evidence of the amount of the up to $100,000 restitution sanction for costs associated with Wilson's disciplinary infraction. Castaneda did not afford Wilson the due process protections afforded by the Supreme Court in Wolf and Hill, and accordingly violated Wilson's due process rights.
Well, there was a Wolf hearing. The question, as has been posed by the appellant here, is there a due process violation? And what I'd be interested in the benefit of your thoughts on, Mr. Lindiger, is we've got law, and the Supreme Court's got law, that state procedure requiring federal procedure, that type of an argument doesn't follow. That a violation, for example, of a state administrative code does not necessarily equate with a violation of the federal due process. Can you address that for us?
Absolutely, Your Honor. We're not addressing, or we're not arguing that violations of the IDOC policies were violated. We do cite to the IDOC policies in the briefing as support for our argument, particularly on what Officer Castaneda maybe could have done. But our arguments are rooted in federal due process case law, both with Wolf and Hill and this court's jurisprudence.
So are you addressing or challenging the sum evidence standard or its application?
Both, Your Honor. Well, Your Honor, the court asked 3 questions in its initial order. The court first asked whether some evidence of the amount owed is necessary to satisfy due process requirements in relation to a restitution sanction. It is. The standard is the same standard. It's lenient. It's in Hill. Absolute precision is not required, but there has to be some evidence of the amount. If not, correctional officers will have free rein to assess wholly speculative assessments bearing no relation to the actual injury. We're not advocating for a bright line rule that medical bills or invoices have to be presented. Evidence of the amount can be conveyed to the inmate, to the prisoner, in a variety of ways. We cite just one of them, the Freeman v. Carroll case out of the 10th Circuit. There was a memorandum summarizing the amounts, not the actual bills provided to the inmate, but a memorandum summarizing the costs. That would be sufficient. Officer Castaneda did not provide any evidence of the amount itself, and that is a violation of Wilson's due process.
It seems to...
No, go ahead. No, go ahead. I've already asked.
It seems to me we have Castaneda, in your theory, not providing the evidence or any evidence now or later, at the time of the hearing or ever, because Mr. Wilson gets back this notice that, there is none. Should we be looking at that too when we look at what does the sum evidence require standard? That's my question.
Yes, Your Honor. That was another one of the questions that the court presented in its initial order requesting briefing. The sum evidence of the amount owed may be relied on or after the disciplinary officer imposes the restitution sanction, so long as the officer comports with the Wolf-Hill due process requirements. The key issue with Your Honor's question is the prisoner must be given a chance to challenge the sum evidence of the amount prior to the deprivation of the property, a pre-deprivation challenge. That did not happen here, Your Honor.
I guess my question is here, even post deprivation, he wasn't provided anything.
You're absolutely right, Your Honor. We're 2 years later and we still haven't seen any evidence of the amount itself.
And you're alleging a violation of a pre-deprivation remedy.
Yes, Your Honor. Yes. There's a variety of ways Officer Castaneda could have held a different hearing later in time once the evidence materialized, but that evidence still has not materialized. Mr. Wilson had most recently in January of 2024, almost a year and a half after the incident, after the restitution sanction issued, another deduction from his commissary account.
I guess my question is the failure to, is the absence even to this day of any numbers support for the insufficiency of the evidence at the pre-deprivation stage?
Absolutely, Your Honor, and that just illustrates the premature dismissal of this case at the screening stage that the district court engaged in. At a minimum, Mr. Wilson is entitled, he had set forth a federal due process claim, articulated it very clearly in his complaint. The district court applied the wrong standard. In fact, instead of viewing the facts in light of in Mr. Wilson's favor, it did the opposite. It construed more than minor injuries based on pure conjecture. At a minimum, this district court should have allowed Mr. Wilson's complaint to see the light of discovery, and that's what we're asking for the court to do here, Your Honor. Just to follow up on that, Your Honor's point, Mr. Wilson did not have a chance pre-deprivation to contest the up to $100,000 sanction because no evidence was provided. The Supreme Court in Wolf stated, though, that some kind of hearing is required at some time before a person is finally deprived of his property interests. Wilson never had that here. He's never been able to challenge any evidence of the amount itself.
So he had a hearing, but you're saying a hearing to actually challenge the evidence where the figure is set?
Well, it doesn't have to be a separate hearing. It could have been all together, Your Honor. And I think what's important, there's two cases, if you read the Supreme Court in Wolf and Hill and this court's decisions in the Williams v. Wright case and the Ton v. Dittman case cited multiple times in Wilson's briefing. If you read all of those together, in sum, if a prisoner has the ability to challenge both the existence and the amount of the liability and the restitution sanction at a pre-deprivation hearing, all in the same hearing, federal due process rights are not violated. That did not happen here, Your Honor. At most, Mr. Wilson was able to forward a self-defense argument, challenge the liability aspect of his disciplinary infraction, even challenge potentially the non-restitution sanctions, the restrictive housing and such that flowed from the liability finding. But once Castaneda did everything together, issued the restitution sanction of the up to $100,000 without the some evidence, any evidence, not some evidence, without any evidence of the up to $100,000 restitution amount, that's where the federal due process, Wilson's federal due process rights were violated.
Well, there were statements. One was more detailed than the other. We know an ambulance obviously took the individual with the cane away, so there's some expenses. That's why that goes to my question of challenging what occurred here in terms of its in theory or challenging how that theory was applied here. And you said both.
I do, Your Honor. We are challenging both. And respectfully, Your Honor, we actually don't know if an ambulance was used. All the statement said was the inmate was later sent to an outside hospital for his injuries. We don't know if an ambulance was called, which I concede would be more expensive than if a correctional facility just took that inmate in a van and maybe charged for mileage, under the government standard. But that's precisely the point, Your Honor. There are no details in the record regarding any purported injury. No body part was even mentioned. No description of the treatment and no information on the method of transport to the outside hospital, which is not an insignificant fact.
And maybe it might be clear if we're not contesting the liberty interest, which resulted in him losing some credit. We're contesting here, Mr. Wilson is only contesting the property interest and that he was denied due process as to the property interest.
Precisely, Your Honor.
And so when we're looking at the property interest only, is the contention that he was denied some evidence that would substantiate the officer's estimation of up to $100,000?
Exactly, Your Honor.
Would you like to reserve the remainder of your time?
Yes, Your Honor.
All
I
right.
forgot the yellow
Thank you,
light went
Mr.
on at the
Lindiger.
minute.
Thank you.
Your
We
Honor.
appreciate your appearance here, and we will give you some rebuttal time. Mr. Yoke, we'll move to you.
Good morning, may it please the court. Wilson is the master of his complaint, and his original complaint in the district court failed to state a federal due process claim following his prison disciplinary hearing. He was found guilty of battery at the hearing and sanctioned, and his federal complaint alleged that there was no evidence of the battery and no evidence of medical bills to support the imposition of restitution as a sanction. But his complaint and the documents that he attached showed that there was some evidence to support the battery and that there was some evidence to import imposition of a sanction of restitution at the time of the hearing, and that satisfies federal due process. At the time of the disciplinary hearing, the amount of evidence required is, in fact, some evidence, and that's true for the sufficiency of the allegation and also for imposing restitution as a sanction. And the review of the video showed that the victim was battered, and the statement that he was transported to an outside hospital provided that evidence.
Let me ask you it this way. So the court has evidence that the victim was battered and that the victim was later taken to the hospital. What if the victim got to the hospital and he felt better by the time he got there? We don't know if the hospital's 30 minutes away, an hour away, 20 minutes away. It can happen. Some time passes, he feels better, so they turn around and come back to the prison. What if he got to the hospital and they assessed him and they said, what you need is over-the-counter ibuprofen and ice. So take these pain meds and ice. He's returned to the prison. Or what if he got to the hospital and he needed some serious intervention like surgery or some other serious intervention? We don't know which of those three scenarios happened. They're very different scenarios. Why is it proper to infer at this complaint stage the most expensive and worst outcome as support for up to $100,000 for the district court? Why is that not an inference against Wilson at the complaint stage?
So at the complaint stage, there's a few things I think to unpack. What Wilson alleged in his complaint was that there was simply no evidence, which I think is important. I think that there's also important to distinguish the difference between imposing...
So Wilson's pro se.
Yes.
Okay. He said no evidence. Let's say he had said insufficient evidence. Are we in the same place?
When we look at what he attached to his complaint that established that there was some evidence, I think that's the same thing, and that there was some evidence. And it's I think important also to consider that the cap operates simply as a cap. It's not a finalized amount. There are mechanisms for Wilson to and offenders like him to challenge those amounts later.
But to date, he's received nothing. The debits, he's told us, the debits are still coming out of his account, and time has passed, and he's still received nothing that could substantiate where in this scale between 0 and 100,000 he's going to have to stop paying. So to date, he can only assume he's been punished to pay all the way to 100,000. He's been not told anything else.
I would say that the record as we have it in front of us is that we don't know what he has or has not received. What we have from his record is one request that was made in July, which was a couple of weeks after the second stage appeal, the central office appeal. What we have showing restitution, what looks to be restitution deductions are in his disclosure statements for the filing fees. And so there's nothing in this record that shows us that Wilson has that the facility has never received a bill and that the facility is making up these amounts.
So what about, what do you, where they tell him there is none, he asked for something and they say there's nothing? What do you make of that?
I think that is one. It could be one of two things. One, it could be what he asked for was documentation that he asked for the order or an order from a court that was not there, and it's also possible that medical bills were not available yet. The incident happened at the end of April. He makes his request in July. That's not an inordinate amount of time, I think, for medical billing to come through.
And isn't the important question whether that's a federal cause of action? I mean, Indiana's got this policy that says if it's not possible to determine the amount of medical restitution at the time of the hearing due to ongoing medical treatment or delay in receiving the bills, the officer may assess a medical expense restitution sanction up to an estimated amount. That's the code. He can't sue on the code. That would be bringing a federal claim on a state disciplinary code, correct?
Right, and that's why I think it's important, again, to distinguish between the time of the hearing and what happens at the hearing and these debits that look to have occurred in his commissary account later. He may have other claims against other prison officials. They just may not be against Lieutenant Castaneda for her conduct and whether he received due process as required at the disciplinary hearing itself. And what the district court, I think, saw in his complaint was he received notice, he was able to defend himself at the hearing, he requested video review, that review was completed. Lieutenant Castaneda then issued a written finding with issuing her reasons for the decision and the decision to impose restitution. And the district court said that satisfies due process for the hearing. And the complaint that I have in front of me and the administrative appeals of the disciplinary process that Wilson raised were all about the hearing and about the process he received at the hearing. And so even in filing his lawsuit, it was about 7 months from the time that he filed his lawsuit to the time that the district court issued its order denying his motion to reconsider the dismissal. And at no point did Wilson suggest that he had other claims against other officials for these amounts. So the point being there is that there may be other claims that he has. They just may not have a due process claim under the Wolf Hill framework for what occurred at the hearing.
And so I guess looping back to those Hill factors, and this is where my question was going just a moment ago, we focused a lot on what substantiated the need to impose, right, this sanction. So does Hill, in the direction from the Supreme Court, overlay when we're looking at restitution? I understand what the Indiana policy is, and that's up to. But we have this Hill language that says there must be some evidence before the property interest is taken. And so is there any evidence to support the restitution up to $100,000? I guess what I'm asking is where do we pull this number from?
Right, and I think it's important, I think, to distinguish between a fixed amount and a cap. And what the cap does is as an example, if he had suffered a broken hip and needed extensive surgery, a cap would protect Wilson in this case. That could easily balloon into more than $100,000. It's very different than a broken window where we can a facility could have an estimate or even a full repair bill within even a week, and there was only a week between the incident and the disciplinary hearing itself. And so it's just different when I think we're dealing with medical bills and restitution. And so a cap is not a final number. And to get back to, was there some evidence to impose the sanction itself of restitution? The answer is yes, because
My focus is just on the amount itself.
on the amount, I think the amount being subject to refinement later comports with due process. And again, it's because Wilson would have other ways to challenge the amounts as they're debited. He may have other claims against the officials who debit those amounts. And the state is going to, at some point, have to present, at some bills or something. The state is not saying that it can debit his account indefinitely. It's just at the time of the disciplinary hearing itself, that amount does not need to be proven or shown, because we have to move quickly in prison disciplinary hearing processes. Inmates are living in close contact with each other, and there are those other Wolf Hill important factors for moving swiftly, and which is different than, I think, a civil case or a criminal case.
So the argument is that Hill would not apply in the restitution context?
I think it applies in that you have to have some evidence to support imposing the restitution sanction.
Okay.
Because he does have a property interest.
Thank you, Mr. Yoke. Mr. Lindiger, we'll go back to you with 2 minutes for rebuttal. Thank you.
Thank you, Your Honor. If I knew I had 2 minutes, I would have written a little bit more. As it stands, Your Honor, thank you. Addressing a few points that the Attorney General made, as he did in his brief, he's focused on restitution as a sanction. Okay? There is nothing in the record supporting the amount of the restitution versus supporting restitution as a sanction. Those are two separate and distinct items. The AG said there are mechanisms for Mr. Wilson to challenge the amount later. I don't know what mechanisms they are. The AG has not disputed that Mr. Wilson has exhausted all of his administrative remedies. He's tried to appeal this restitution order as well as the disciplinary hearing finding. All the way up the chain, it's set forth in the record, and now we're here. This is his last chance to challenge the restitution amount. The AG also stated that Castaneda provided reasons for her finding of the restitution, the up to $100,000 amount. She did no such thing. On SA-9 in the record, Castaneda's reasons just merely cited to the video snippet summaries. She did not provide any additional analysis, no written full write-up of what occurred. Finally, the AG conceded that Mr. Wilson's account cannot be debited indefinitely. But when does that stop? He has more than a decade left in prison the last time I checked. Is he going to be deducted money from his account every January, middle of the year, without any explanation, without any evidence supporting this incident that happened in July of 22? That is not sustainable. And for those reasons, Your Honor, we ask that this court reverse the district court, allow Mr. Wilson's complaint to proceed, and remand with instructions to serve his complaint on Officer Castaneda. Thank you.
Mr. Lindiger, you were appointed by the court, and you have our great thanks, you and your firm, for all your hard work. So thank you for your submissions. Mr. Yoke, thank you, as well as the AG's office. The case will be taken under advisement.
Thank you, Your Honor.
We'll move now to Appeal 24-1099, Nicodemus versus City of South Bend. And Mr. Falk, we'll begin with you.
Thank you, and may it please the court. People have a First Amendment right to be in public and to approach, observe, and record police activity as long as there is no interference. But the statute here, Indiana Code 3544.1-2-14, contains no standards whatsoever and allows individual police officers to create 25-foot floating buffer zones around themselves that can repeatedly be added onto by different officers to push persons back farther and farther away from police activity, including persons like Mr. Nicodemus, who intends to approach, observe, and record, because that's what he does. The Supreme Court has told us in Schenck that 15 feet is beyond normal conversational distance, and Mr. Nicodemus has verified, depending on the circumstances, that it's often difficult or impossible to capture what is happening on his videos from 25 feet.
Mr. Falk, let me inquire. The challenge here is a facial challenge, not an as applied. Is that correct?
Yes, sir.
And with regard to the theory itself, we have a district court opinion that resolves the matter on substantial overbreadth.
Yes, Your Honor.
We have obviously arguments below, similar to the arguments that we have here with regard to intermediate scrutiny, et cetera. Is Mr. Nicodemus offering a substantial overbreadth argument or not?
No, Your Honor. We have argued consistently the problem with this law is it contains no standards whatsoever to restrain the unfettered discretion of the police. Now, I think if we were in law school, we would then talk about how arguing lack of standards is very similar to saying substantial overbreadth. But I think the easier way to look at this is to look at this statute. This statute doesn't have any standards at all. Police, for any reason whatsoever, can say, in effect, get out of my face, move back 25 feet. If you don't, you're under arrest. And other police officers can say, hey, move back farther and farther. And that is a problem, given that lack of standards when it comes to the First Amendment is clearly unconstitutional. This court in Alvarez, like
but
every...
I guess, I question whether or not we should be pulling off the shelf this notion or those cases dealing with unbridled discretion when we are, I guess we have to premise this first in classifying what type of law is the Indiana buffer law. To get even into the unbridled discretion conversation, is it your contention that this law is content-based or content-neutral, which will help trigger kind of which door we go in next?
Sure. I don't think it makes any difference to the end result, but let me answer the question, of course. This court in the Smith case held that when a statute, or in this case it was a rule, has no standards and impacts on the First Amendment, it is content-based because the lack of standards allows for content-based decision-making. Now, in other cases, this court has enunciated the reasonable time, place, or matter, content neutral, and then said as a fourth thing, it also contains no standards. I think it makes sense to look at this in the content-based area just because it emphasizes the fact that this is a direct burden on the First Amendment. But I would add, however, let's assume it's not a direct burden. Let's assume it's only an indirect burden on speech and speech activity. What has to be shown? Well, the state still has the burden to show that the statute is not substantially broader than necessary to further a significant state interest. Keeping police from being interfered with in the job they do is a significant state interest. But this statute is way broader than that because it allows police, for any reason, to push people away. Indiana has a statute that allows police to declare an emergency incident zone around an emergency incident, a fire, an accident, an arrest, etc. Indiana has a statute that prohibits forcible interference with the police. Certainly, if Indiana wants and feels that there is a need to supplement those statutes with other statutes that protect police from interference, they can do this. But this statute's not that. This statute has no standards whatsoever. And given how important citizen journalists have become in getting close to George Floyd, in getting close to Eric Garner, in reporting in ways that traditional media no longer reports, because all of us now are potentially citizen journalists because we all carry cameras in our pockets.
Has this ever been used outside of the licensing or permit context, this theory?
Which theory, Your Honor?
The Smith case. That content-neutral laws can be treated as content-based depending on how it impacts speech. And so I just haven't seen where this theory has been applied outside of licensing or permitting context. I think it's the reverse of kind of what we had in Smith. And so I'm just questioning whether or not this theory has been used this way.
Well, in the
unbridled discretion theory, I'm sorry.
Right. In the Supreme Court case that dealt with the inability of persons to wear political clothing in the shoot, in that case, I apologize.
Mansky?
Thank you. I happens to get old. I apologize. We cited that case, of course. In that case, of course, that was not a licensing case, but the court relied on the unbridled discretion. to find that that was unconstitutional.
But it seems to me in that case, it did so in the context of the narrowly tailored inquiry. So you don't have to ignore the discretion question, but you look at it when you're trying to figure out whether the state is adequately or appropriately addressing their significant government interest.
Well, again, we can argue the two separate points, whether we apply unbridled discretion or we look at whether it's substantially broader than necessary to meet the second prong of Ward. We come out with the same answer, right? There are no standards here. You are impinging on First Amendment rights here without standards. You have a statute that allows, for any reason, persons to be prohibited from what this court recognized in Alvarez as a constitutional right.
I appreciate you focusing us in on unbridled discretion. Is the concern that officers would be more friendly with certain citizen journalists than others in terms of whether it would be enforced?
I think there are lots of concerns. I think the concern, of course, is that no one wants to have someone putting them on video or taking pictures of them. And in Houston versus Hill, the Supreme Court made it clear that unfortunately police officers have to tolerate people, in that case, yelling at them. I think that there's a concern that there's a lot that will not be discovered, that there's a lot of information out there that would not be obtainable without the ability of persons to get close and observe. It's dark. I can't see very well. I need to get close. I need to get the ID number. I need to be able to see when there are 3 or 4 people on the ground. Are they helping that person, or are they restraining them too roughly? All of that is lost when you're able to say, go back 25 feet. And as in Mr. Nicodemus's case, go back another 25 feet.
And I certainly see the point that you're advocating for, Mr. Falk. There are some restrictions. It's got to be a knowing or intentional encroachment. The officer would have to be performing lawful duties. It would have to be after an order to stop approaching. I mean, the way that 44.1.214 is drafted, it seems to have some restrictions. The question is, do those arise to a level of being unbridled?
Yes, Your Honor. I mean, the idea that you have to be lawfully engaged in execution of your duties, that's a defense 6 months down the road after you've been arrested. That is hardly a standard on the ground that protects you from the First Amendment standpoint. Having to go back 25 feet, obviously that's not a standard. That's the boundary set up by the statute.
What about the warning requirement?
Well, the warning requirement is basically saying, I'm about to violate your constitutional rights, assuming plaintiff is correct, right? Being told that you have to do something which violates your First Amendment before I arrest you for it doesn't mitigate the First Amendment violation at all.
Very good. Thank you, Mr. Falk. We'll reserve the remainder of your time.
Thank you.
We'll now move Ms. Lawrence to you.
May it please the court. We ask this court to affirm the district court's decision that Indiana's encroachment law, which regulates conduct, not speech, does not violate the First Amendment on its face. And that's primarily for 2 reasons. The first is that Mr. Nicodemus cannot show that the plainly legitimate sweep of the law is substantially outweighed by First Amendment concerns. And second, because insofar as the right to record exists, the encroachment law does not bear upon that right. Now, I want to start with something that my friend on the other side discussed, which was whether we should be getting into the idea of unbridled discretion. And unbridled discretion only comes into play if there is a First Amendment right that is being expressive activity is either being permitted or denied. So Lakewood talked about this specifically in that they said the unbridled discretion analysis does not apply anytime a law gives government officials discretion. And the example that they used were building codes. If, say, a newspaper were to apply for a building code, they could not then say this is an unbridled discretion because there's discretion for the government persons there. In this case, the only way that this court should do unbridled discretion analysis is if the law is narrowly and specifically tailored at conduct associated with expression. That's the Lakewood standard. Now, the reason why this law isn't narrowly and specifically tailored at conduct relating to expression is because Indiana's other laws, its emergency law and its forcible interference with police law, do not actually cover the activity that this law is trying to protect against.
What do we do if we remove it out of the unbridled discretion theory? Accept the state's position that this is actually a content-neutral law and move it under O'Brien?
Yes, Your Honor. If we move this under O'Brien, this law is clearly focused on the state's purposes to protect police officers in performing their lawful duties. So, for example, if a police officer is responding to someone who's having a mental health crisis and the police officer hears someone coming up behind them while they're trying to respond to the person with the mental health crisis, they can say, hey, I need you to stay 25 feet away while I'm dealing with this. The state has an interest in police officers being able to conduct their duties without having their attention divided. So if, for example, a police officer is directing traffic at an event, he needs to be able to pay attention to the cars that are coming, to the pedestrian traffic that's occurring, and he might say, hey, I need everyone to stay 25 feet away from me so that I can focus my attention on the citizens that I'm supposed to be keeping safe in this instance. Now, and then the question is whether or not this law is then a fit to the means of the government in this instance under O'Brien. And here it is, because it's limited to a 25-foot zone, which is a relatively short zone that the district court found. The distance to a three-point line in an NBA basketball court, the distance between a average two-car garage. It's about the distance from the front of the gallery to this bench, a distance that can very quickly be traversed by someone who's coming towards a police officer when the police officer needs the opportunity to keep his or her attention focused on the matter in front of them.
Mr. Falk has brought up, though, badge numbers, hearing conversations, the Schenck case indicating that would not be enough. It's not going to be the same as being 8 feet away or 10 feet away, correct?
Certainly, Your Honor, and I think there are three reasons why that type of analysis isn't helpful here when we're looking at a facial challenge. So the first issue here is that the question under the Schenck case was whether or not the participants could participate in a conversation with people. Here, Mr. Nicodemus hasn't asserted any right to participate in a conversation with the police officers or with their witnesses. Second, Alvarez says that the right to record is not unlimited. And Alvarez specifically points out, relying on the principles of an expectation of privacy from Katz, that there must be the ability for police officers to have private conversations. So, for example, the right to record does not mean under Alvarez that someone may come and put their phone directly in the face of a rape victim while she is talking to a police officer.
But isn't there already protection for that? That the officer in Indiana, in that instance, that hypothetical that you just provided, they can declare, based on this criminal investigation, I need you to move back. You cannot put your camera in the face of this victim because I am actively engaged in an investigation. And so I guess that's where the rub is in that example, is that already exists.
That may exist, Your Honor. It's not clear under the emergency law whether that would be an appropriate application of that law, because the emergency law specifically talks about when there is a location, like a fire or a car accident or a hazmat spill, where an officer can say, hey, I need everyone to get back. And that simply is not, and so that may or may not happen if, let's say, a police officer encounters someone who's in distress outside and the person starts speaking and the officer is trying to determine what's going on. The officer might not have established, I am doing an official investigation here right now that would be protected under the emergency law, but still needs to be able to focus her attention on the person that she is supposed to be assisting in that moment without that divided attention.
Ms. Lawrence, same question I posed to Mr. Falk. We have a ruling from the district court here on substantial overbreadth.
Yes, sir.
We have arguments in the district court and then here with regard to intermediate scrutiny, unbridled discretion, et cetera. What is the state's position with regard to the review of the district court decision on the analysis of substantial overbreadth?
Well, of course, this court would review de novo any legal conclusions of the district court and can affirm the district court for any reason that is within the record.
And I appreciate Mr. Falk's response, which was there's overlap here. But specifically here, we're talking, the debate we're having, the discussion we're having, is somewhat different than was had at the district court.
Perhaps, Your Honor, but at the end of the day, the question is whether or not this law actually first regulates conduct or speech, which the district court found that it regulated, for the most part, conduct. And if there are instances where it does implicate First Amendment rights, those can be brought as applied challenges. This isn't opening the door for a total carte blanche, but instead it's saying as a facial matter, this is regulating conduct. But then second, under whether or not this right to record is an infinite right, there's nothing in Alvarez that says the right to record has to be 8 feet away or 10 feet away or 4 feet away. Rather, Alvarez says there's a right to record generally, and nothing in the law says that Mr. Nicodemus has to stop recording. It just says that in some instances, police officers may say, I need you to stay 25 feet away while I'm doing my official duties in a way, and so that my attention is not divided between what is happening in front of me and people in the dark in a situation where you don't know what's going on. And that is the purpose of the law, and that is the factual finding that the district court used that is helpful to decide this case here.
Thank you, Ms. Lawrence. We'll move to Mr. Smith. You'll have your full minute and a half.
May it please the court, Joseph Smith for the City of South Bend. The city agrees with the arguments of the state that the statute is constitutional and the court should affirm on that basis. Additionally, as to the City of South Bend, the court should affirm because there is no South Bend policy at issue here. The policy at issue here is a policy of the state of Indiana. Plaintiff has relied on the Bethesda Lutheran opinion in support of the proposition that a government entity is liable anytime one of its employees does something that a state statute says they are allowed to do. The Bethesda Lutheran decision, the discussion on that issue is dicta, and it is wrong. It is dicta because Bethesda Lutheran was a compelled action case, not an authorized action case. So the court had no occasion to say in that case what the rule would be in an authorized action case such as this. Snyder v. King, also cited by plaintiff, is the same. It was a compelled action case, not an authorized action case. It is dicta as well. The Second Circuit has already recognized that the Bethesda Lutheran discussion of the authorized action versus compelled action issue is dicta. And that was in Vives v. City of New York, 524 F. 3rd 346, which we did cite to the district court. The Bethesda Lutheran dicta is wrong because that is not what was said in Surplus Store, as we've said in the brief, and I see I am already out of time. If there are no more questions, or no questions at all, the court should affirm for the City of South Bend, both on the First Amendment and on Monell.
Thank you very much, Mr. Smith. Mr. Falk, we'll give you 2 minutes on rebuttal. Thank you. You're welcome.
The bottom line, Your Honors, is that the statute here allows people to be pushed back away for no reason whatsoever. The state can hypothesize reasons why you may not want to be able to get close to the police. Valid reasons. I would submit that many of those are already covered by existing Indiana law. If they're not, then Indiana should pass a law that narrowly deals with that. Alvarez.
Would resisting law enforcement not cover that, though?
I'm sorry?
Indiana resisting law enforcement.
Well,
Interfering
that
with the criminal
requires force.
investigation?
That
Yes.
requires force, Your Honor. So I don't know. But the point, of course, is Indiana knows, the legislature knows how to pass laws, and they could pass a tailored law. Alvarez requires that there be a reasonably close fit between means and ends under intermediate scrutiny. There isn't that fit here. We know what the end is. We all agree it's a valid end, but there's not that fit. And I don't think it makes any difference once we get to O'Brien versus Ward, whether we're talking about conduct or speech, but I would remind the court that this court in Kemp recognized that the right to record necessarily includes the right to approach and observe. All of that is part of the process that creates speech, and all of that is disrupted and interfered with by this statute. And I would just say at the very end, concerning the Monell argument, obviously it's somewhat academic, the state's here as a party, but the distinction that was drawn has been drawn by this court and many other courts, I believe, is between being compelled to act by a statute or being authorized. South Bend's not compelled. It has decided to use this statute. It is therefore subject under Monell to liability. Thank you.
Thank you, Mr. Falk. Thank you, Ms. Lawrence. Thank you, Mr. Smith. The case will be taken under advisement. The court will next call case 24-1119, Eddie Richardson versus Kareem Karbouche. We have Mr. Hassan here present in the courtroom. And Mr. Hassan, thank you for your patience before. We appreciate that.
Thank you.
And we have Ms. Martirosian appearing by remote means. Ms. Martirosian, can you hear us? Doesn't look like she has mute on. Ms. Martirosian, can you hear me?
I cannot hear. I don't know if you are able to hear me.
We can hear you, but we want to wait.
You are able to hear me? 1 second.
I see there's a mute in the upper right-hand corner.
It looks like it's live. Did it say the word live?
Mm-hmm.
Off the record, you can imagine what this was like during COVID. It's happened almost every time. Ms. Martirosian, can you hear me now?
I'm going to go ahead and call in. My sincerest apologies.
That's fine. We'll have you call in. Do we have a number for her?
As I'm unable to hear.
All right. We're going to email you a number. Mr. Hassan will wait. He's been waiting patiently all morning here, so we'll ask him for a few more minutes. Oh yeah, it does say mute, doesn't it?
Mm-hmm. It does.
Ms. Martirosian, your mute button.
It's not on our end, is
Now
it?
it's off.
Okay.
Ms. Martirosian, can you hear us now?
It's muted on our end.
Welcome to Zoom for Government. Enter your meeting ID followed by pound.
You could go out and get it before we start. Or do you want me to Teams?
Enter your participant ID followed by pound. Otherwise, just press pound to continue. Please enter the meeting password followed by pound. You have not. You are in the meeting now. There are 7 participants in the meeting.
Ms. Martirosian, can you hear me?
Hello, this is Ani Martirosian. Can you hear me?
Yes, we can. Can you hear us?
Okay. I am still unable to hear you judges on my phone also.
You are now in a breakout.
All right. Ms. Martirosian, can you hear me now?
Hello? Hello? Hello?
Can you hear us now?
I am not sure why there is an echo.
We can hear you. Maybe turn the audio off on your computer.
And she's gone.
Mr. Hassan, where did you come from? Where did you come from? What part of the country?
Madison.
Madison. Okay, very good. Thank you. Ms. Martirosian, can you hear me now?
I cannot hear you, Your Honors. Is it possible that it is muted on your end?
We've checked and it's not muted on our end.
Another breakout session. You are now in a breakout session.
Can you hear us now?
The host will move you into another breakout session. You are now in a breakout session.
Sounds like there's an echo on her end. Yeah. Should she turn off her audio? Yeah. Ms. Martirosian, can you turn off your audio on your computer? She looks like she's muted.
Yeah, does it?
Yeah.
Do we have access to the chat? So we can put these questions in the chat.
I don't know that we can. Yeah, I don't know if I just don't know.
Hello?
Hello, we can hear you. Can you hear us?
My apologies. I still cannot hear you, Your Honors. I did check all my system yesterday, and I was able to speak to the individual that was helping me, but now for some reason I'm unable to hear you.
We can hear you. Do you have some there's no mute on from your end? Any kind of a volume? That's fine. Oh, that's fine. Yeah, absolutely. Thank you. What about if you just used your telephone, called in with just the telephone? We're going to take a brief recess, and we'll come back on if we're able to get this to work, okay? Mr. Hassan, again, thank you for your patience. The court's going to stand in recess, Sylvester, just for a second here. All right, thank you.
The host will move you to another breakout session. You are now in a breakout session. The host will move you into another breakout session. You are now in a breakout session.
This is Ani speaking. I unmute. The problem.
Testing 1 2 3. Testing 1 2 3. Test test test. Can you hear anything from there? Let's see. Can you go to the bottom right of your computer screen?
Of course.
And then you see where there's like a
little audio-looking thing, like a speaker?
Yes.
What's that select to? It's not off, is it?
No, it's on. I was listening on the speakers, the YouTube live. Previously, it was working.
She is remote. However, we have been successful thanks to the clerk's office. So we're going to continue now with the oral argument in this case 24-1119, Richardson versus Carbouche. Mr. Hassan, I'll recognize you first.
Thank you, Your Honors. My name is Tyus Hassan. I am counsel for the plaintiff appellant, and if it pleases the court, I will present this case.
Yes.
This case is about the performance rights to a sound recording, and it raises a federal question under the Copyright Act. This sound recording was created by the plaintiff in 2012 when he was 16 years old, and he named this sound recording Hood, Push and Wait, or HPW. HPW is a unique arrangement and expression of melody and digital sounds. Those sounds include strings, 808s, rim shots, orchestra hits, and kick drums, to name some. On October 7th, 2012, plaintiff uploaded HPW to a widely known music file sharing website called soundclick.com to promote himself as a music producer. SoundClick date stamped plaintiff's upload of HPW, and plaintiff adopted SoundClick's copyright notice to all users that all materials found on the site are proprietary, and that any use of those materials requires permission from the copyright author. About 7 months later, on May 5th, 2013, plaintiff hears HPW sampled into a popular 2013 hip-hop song called Ain't Worried About Nothing, or AWAN, which is performed by the defendant appellant. Now, sampling is when any part of a pre-existing sound recording is copied into another work. And if it's done so without the permission of the sound recording owner, that's infringement under the Act. That's according to the Sixth Circuit's analysis of the rights of sound recording owners under the Copyright Act in Bridgeport Music versus Dimension Films. According to the Sixth Circuit, the Copyright Act provides the sound recording owner with the exclusive right to his entire sound recording. The Sixth Circuit made particular note of and emphasized the congressional change to the Act under Section 114 to include that operative term entire when defining the extent of the sound recording owner's right to his sound recording. The Sixth Circuit interpreted the Act to, by its very terms, preclude a substantial similarity test for infringement between the infringing work and the
If we
plaintiff.
accept Judge Maldonado's position that when she hears it, and she said, you know what, based on the evidence, could have been, might have been, but because we're here on a motion for summary judgment for sampling, what evidence did we have that would support the representation you're making to us this afternoon that this particular sound was sampled into the song?
Well, firstly, the threshold of sampling and infringement was analyzed in the Sixth Circuit. And according to the Sixth Circuit, the sound recording owner has the right to his entire sound recording, which means there's no need for a finding of whether AWAN is a substantial sampling of HPW.
What evidence do we have that there is a sampling in this case?
The evidence is the plaintiff who created HPW. He specifically describes with particularity the sounds of HPW which he hears in AWAN.
And so I understand his allegation, but is there any evidence that substantiates that allegation or his belief that that is the actual sound recording?
Your Honor, there's a lot of evidence. Again, going back to the Sixth Circuit, the threshold is very low. It only requires any amount of sampling, and that's infringement. And
if I may,
yes,
if I may, I see it as two options here. Either Carol Boach sampled, meaning out and out, took the sound and copied the sound, kind of cut and paste of the sound, or the musical composition copyright, which is a separate category. Carbouche created the music that sounds just like what Mr. Richardson created. So rather than copying a recording, cut and paste of a recording, so to speak, listen to what Mr. Richardson did and then sat down and recreated the notes and recreated the sound. And so I have the same question that Judge Pryor is asking. Given those two scenarios, what evidence is in the record that it's the first one, that he actually copied the sound versus sat down and reproduced on his own the musical composition?
Well, that scenario that you've just described, that's limited. That's not describing what the Sixth Circuit described in Bridgeport Music, where it says that it cited to a law journal to explain that sampling, for one thing, is extremely common in hip hop. So for a hip hop artist to sit down and imitate or simulate another artist, that's not what happens in the industry. The Sixth Circuit cited to a law journal, and the words of the court is that sampling in hip hop is extremely common. Those are the words of the court. It's cited to a law journal to explain why sampling is extremely common in hip hop. It's because it saves time and it saves money to just take music samples from another artist who's already done the work, and technology makes it easy. As for the melody, we have an expert who charted out both works and scores and determined that AWAN copies 6 out of the 7 motives. Those are the musical ideas expressed in HPW. AWAN copies 6 out of the 7 motives all throughout the song.
Did the expert say, and so therefore it was sampled, or therefore it was copied?
The expert stated that the melody was misappropriated, and the standard laid out by this court in Atari Inc. versus North American Philips Consumer Electronics, and again in Wildlife Express Corp. Versus Carol Wright Sales, is whether an ordinary reasonable person, not an expert, whether an ordinary reasonable person would conclude that the plaintiff's work has been misappropriated. And again, given the low threshold for infringement in cases of sound recordings, that finding could be made just by listening to the two works. It doesn't require an expert, although we did have an expert. And the expert stated that it does copy the melody, and that melody is probative of sampling, because even though the melody is an unprotected element of the sound recording, it's still probative that AWAN was sampled from HPW, because this court has said in Design Basics versus Signature Construction that the inquiry into copying is not restricted to just the protected elements of a work, but it includes the unprotected elements as well. The inquiry
on that point, and I'm glad you brought up Design Basics because it's important. Does Design Basics map onto the sound infringement copyright? Or if it does, how does it do so?
Well, because it generally states that when determining whether there's copying, you're not restricted to just the protected elements. You can look at whether you find similarities that you would not expect to find had the two works been created independently of each other. And to the point that AWAN was never created independently of HPW, the expert states that the commercial success of AWAN is owed to the originality of the musical ideas and motives expressed in HPW, because it is the originality of musical ideas and motives expressed in a song that is key to that song's success and popularity among fans.
Did you take any depositions where you asked how Mr. Carbosh's producers created the song, or asked whether they relied on sampling for this particular song?
No, but the district court noted that the plaintiff already spoke with the alleged producer of AWAN and could not show that it was proven by speaking with the director. And also this court has stated in JCW Investments that direct evidence of infringement is hard to come by in these cases. These cases are typically proven by circumstantial evidence, which we have plenty of.
Would you like to reserve the remainder of your time for rebuttal?
No, Your Honor, I'll continue.
That's fine, thank you.
So we believe that a preponderance of all this evidence shows that AWAN is sampled from HPW, which means the AWAN is a derivative of HPW, which means the plaintiff owns the copyrights to AWAN, as it is a derivative work of HPW under Section 106(2) of the Act. The defendant has no copyright to AWAN. even though he added lyrics and vocals to the song, because Section 103A of the Act says there is no copyright to work which employs pre-existing work which has been used unlawfully, as it has been here. Only the plaintiff has the right to perform AWAN by digital audio transmissions, such as under Section 106 of the Act, such as through YouTube, such as through the Apple Music website, such as through various interactive services which have been licensed out by ASCAP, that major performing rights society, such as through all these means through which the defendant has been unlawfully, willfully infringing and thieving the plaintiff's performance rights for more than a decade. This court said in Wildlife Express Court that willful infringement can be found where the defendant has ignored the plaintiff's notices of copyright. Where the district court noted that this is not a case, lacking notice of plaintiff's copyright, that the defendant himself acknowledged that on May 5th, 2013, that the plaintiff contacted and confronted the defendant on Twitter to demand credit for his work. The plaintiff even provided the defendant with a link to HPW on soundclick.com, where it is date stamped 6 months before the release of AWAN and where it can be heard.
Thank you, Mr. Hassan. Thank you very much.
Okay, thank you.
We'll now move to argument from the appellee, Ms. Martirosian.
Thank you, Your Honors. Good morning, and may it please the court. My name is Ani Martirosian, attorney for appellee Kareem Karbouche, aka French Montana. Your Honors, appellee respectfully requests this court to affirm the district court's finding that appellant has failed to show actual copying of the sound recording in Hood Pushing Weight in appellee's song Ain't Worried About Nothing. Specifically, Your Honors, 17 U.S.C. Code Section 114B states that the exclusive rights of the owner of a copyright in a sound recording under clauses 1 and 2 of Section 106, which are specifically to produce the copyrighted work in copies or phonorecords and to prepare derivative works based upon the copyrighted work, do not extend to the making or duplication of another sound recording that consists entirely of an independent fixation of other sounds, even though such sounds imitate or simulate those in a copyrighted sound recording. Your Honors, the statute is clear. Whenever there is a copyright registration or copyright in a sound recording, unless they're actual copying of the sound recording itself, there is no copyright infringement of the sound recording itself. And as Mr. Hassan was explaining, and I would like to discuss both design basics and the Sixth Circuit Court. In appellant's brief, it is argued that the incorrect standard is applied to make a determination whether or not there is any kind of copying in a sound recording. And design basics versus signature Construction, Inc., which is a Seventh Circuit decision, it states that for any copyright infringement claim, first there must be an ownership and a valid copyright, and second, that copying of a constituent element of copying work that is original. Design basics, Judge Brenner, I would like to speak to your question. Design basics does set up the general framework of what copyright infringement generally is. However, because the specific copyright in this instance is a sound recording, and the protection extends only to the recording itself, unless a portion of that recording is in any way misappropriated by taking a portion of it, which would be considered sampling, or taken in its entirety, there cannot be any copyright infringement in the sound recording of that specific sound recording. And appellant does argue that the Sixth Circuit states that any kind of, that the threshold essentially for copyright infringement in a sound recording is very low, and that is correct. And as identified in design basics, the two prongs for finding whether or not there was any copying, the first assertion is, was there actual copying that had occurred? And then once actual copying is established, then it moves to make a determination whether or not the copying goes so far as to constitute improper appropriation. The Sixth Circuit generally, in Bridgeport Music, does apply that standard. And when it made a decision whether or not there was copyright infringement of a sound recording, the first question it asked was there actual copying? Was there sampling? And the answer was yes. And in the Sixth Circuit, the court found that regardless of what amount of the sound recording is taken, it doesn't matter how much is misappropriated, it is considered copyright infringement in the sound recording. But as an initial threshold matter, it asked the question whether or not there was actual copying in the sound recording itself. In the instant case, there is no evidence of actual sampling or copying of the sound recording itself. The evidence that is in the record is that 6 of the 7 motifs are copied, which is opined by the expert of appellant, that 6 of the 7 motifs, which are melodies, and are not protected by copyright in a sound recording. Things such as the snare, the 808, the hi-hat, rim shot, cymbal, low brass, piano bells, and other elements. And specifically, those on its own are not protected by the registration in the sound recording itself. In other words, the record is devoid to show that any sampling has occurred, which means that there is no actual copying of the sound recording.
What is your response to Mr. Richardson's argument that sampling is so common in hip hop that we should and could infer that it happened here when you marry that fact with what the expert found, and really what an untrained ear can hear when you listen to the 2 recordings about how similar they sound?
Yes, Your Honor. 2 songs can sound very, very similar, practically identical. Circular 56 of the Copyright Office brings a great example. That a song performed by Adele, Rolling in the Deep, and recorded, and one performed by Aretha Franklin and recorded, are two separate works in a sound recording, and they do not implicate one another regardless of how similar they sound of each other's sound recording rights. Now, as to how common it is sampling in the hip hop industry, specifically speaking to the Sixth Circuit, when the Sixth Circuit made a determination that it doesn't matter how much of the sound recording is taken, it is considered infringement if any portion is taken, is because it is so common. But as an initial threshold, it did make a determination as to whether there was any actual copying of the sound recording. Was the right in any way misappropriated? And further, the Eastern District of Louisiana did address this question of how common it is in the hip hop industry, specifically in the case Batiste versus Lewis. And in specifically that case, the plaintiff on summary judgment brought evidence that it is common in the hip hop industry, and that Lewis and Macklemore specifically had sampled previously to show that they had sampled in this instance. And the court found that that is not sufficient basis to find that there was sampling without anything additional, without any additional admissible evidence of actual sampling and misappropriation of the sound recording itself. Your Honors, also appellant did make an argument that the district court erred in not taking into consideration the statement submitted as part of the summary judgment as admissions by defendant, because defendant, and neither plaintiff for that matter, did address the statement of uncontroverted fact. However, even though it's up to the discretion of the court, none of the facts identified in the brief by appellant are dispositive to show whether or not any portion of the underlying sound recording was misappropriated by appellee, and so it would not be dispositive. And lastly, appellant does request for injunctive relief on appeal, which, at least as a threshold matter, it must succeed on the merits, and an appellant has not succeeded on the merits to show that there was any copyright infringement to justify a request for a permanent injunction on appeal.
Thank you, Ms. March-Rosian. Thank you, Mr. Hassan. The case will be taken under advisement. And I appreciate everyone's patience today. Thank you.
Thank you, Your Honors.